6 exec today, but we will definitely be doing 2, minimum. All right, and I'll get you those after our next break. As you know, Representative Nunez has left our fair committee, and Representative Love from Fish and Game, who I don't see here yet, will be joining us as a permanent member of the Labor Committee. And I just wrote down your name, sir. What's Ron's last name? Pimentel. Representative Pimentel is filling in for Ben Baruti today. So welcome to the Labor Committee. We're going to start pretty soon. Thank you. Representative Smith, welcome. Nice seeing you.
Nice to be here. Thank you.
Yes, please. Representative Toomey, would you lead us in the Pledge of Allegiance?
I pledge allegiance to the flag of the United States of America and to the for which it stands, under God, liberty and justice for all.
Thank you. Any questions of the chair before we start our hearings? Oh, yes, I'm sorry. Clerk, please call the attendance.
Infantine,
Yes, here.
Seaworth. Here. Avalani. Callum. Mackey, myself. Love. Warden. Good morning. Turcott. Here. Prout. Here. Boyd. Here. Huff. Here. Sullivan. Here. Susi. Rod Pimentel for Baruti. Here. Cahill. Here. Di Silvestro. Here. Schmidt. Here. Toomey. Here. Bouchard. Here. Adjutant. Here. Manival. Here.
Do we have any sponsor for House Bill 1124? Representative? I'm sorry, I apologize. I didn't have any pink cards, so I didn't know who to call on.
Oh, no, my apologies.
All right, you can go when you're done.
What's that?
Please submit one when you're done testifying. Thank you.
Thank you, Mr. Chair and members of the committee for hearing my testimony today. I'm here to talk about my bill, HB 1124, to mandate E-Verify in this state. The issue of illegal immigration is one that is top on the minds of my constituents and people all across my district and really this entire state have asked, what can we do to try to alleviate some of the concerns and problems from illegal immigration? Last year, 1.9 million illegal immigrants entered through the southern border. So we have an unprecedented rise in illegal immigrants. We have an unprecedented rise in the past year of drug overdoses. We see a rise of crime and just general economic issues. And so how to solve illegal immigration is one of the issues that's top on my constituents' minds. Now, issues or solutions like providing more border security or building a wall or empowering ICE. One, those are all things we can't do in the state of New Hampshire. But two, those are all policy solutions that are deeply divided. If you look at the poll numbers, many don't support those in our country and in our state. But what is the one solution to illegal immigration that is efficient and widely popular with Republicans, independents, and even Democrats, depending on the poll you look at? Mandatory E-Verify. A majority of businesses already implement E-Verify in this state and across the country. It's relatively easy to conduct. It's a common sense solution to deal with the issue of illegal immigration. All this bill does is mandate E-Verify, which is just a quick check to see if someone that a business is hiring is in fact a legal immigrant. This does not go after illegal immigrants. This does not deport illegal immigrants. All this does is make sure businesses in New Hampshire that are hiring folks are following the law and hiring legal immigrants. So this is a relatively straightforward bill. We have many regulations in this state. This is not a very intrusive one, but this is an important one. At this time, I'm happy to take any questions, and actually I'll just add one more thing. To be very clear, the people of New Hampshire do not want illegal immigration in this state, and this is a common sense solution to crack down on illegal immigration. And I'm happy to take any questions at this time.
Any questions for Representative Baxter, Representative Bouchard?
Thank you, Mr. Chairman, and thank you for taking my question. Where would the information go to after a certain person would apply for a job and is E-Verified? Would it be purged, or where would that go?
Well, thank you, Representative, for the question. So this bill does not outline what happens to an individual that would be an illegal immigrant that applies for a job. One, that's not what this bill is about. This bill is not a punitive measure to go after illegal immigrants. All it does is it mandates and puts the liability on the business so they are not hiring illegal immigrants. Plus, in a way, it reduces their liability because if they're conducting this background check, essentially, they know that they're not hiring illegal immigrants. And so all it does is if they don't pass that check because they are an illegal immigrant, they're no longer hired. It doesn't mean necessarily that they're being deported, but what you would expect over time is if illegal immigrants are not able to pass this check, they can't get a job, they would likely move to other states over time because they're going to go to places where it's easier for them to get a job. So I hope that I'm answering your question in the sense that this bill doesn't outline that. All it does is put the emphasis on the employer to make sure the person they're hiring is legal or not. Does that answer your question, sir? Okay, thank you.
Representative Susi.
Thank you, Mr. Chairman. Thank you for taking my question. Just out of curiosity, and pardon me for not knowing the question, but is this a big problem in New Hampshire?
Well, Representative, thank you for the question. Not only from just constituents, but also businesses in my district. The issue of illegal immigration is one that's top on the minds of my constituents. If you look at polls, it's one of the top 3 issues in the country. So it absolutely is a big issue, and as I outlined, because of just the general economy, rise in crime, rise in overdoses, people are very concerned about legal immigration, so absolutely.
Mr. Chairman.
Representative Cahill, followed by Warden.
Thank you, Mr. Chairman, and thank you, Representative, for taking my question. I wanted to follow up on the question of my colleague, Mr. Susian. Is there anything currently preventing an employer from using the E-Verify system today?
Well, thank you for the question, Representative. There is not, and a majority of businesses in this country already use E-Verify. And there's many businesses in New Hampshire, especially those that operate in multiple states, in some states which require E-Verify, that they already use it in New Hampshire. So this bill just mandates it for every business, but there's absolutely nothing that prevents a business from using E-Verify in this state.
Follow-up?
So in a sense, while the intention may be good, you are in fact telling a business what to do.
Yeah, it's pretty straightforward. This is an additional layer of regulation, and there's some folks, typically from the more conservative side, that might be against this bill for that reason. I would just say that we have a regulatory burden in this country that's $1.75 trillion. We have lots of regulations for the health or safety of a variety of different things. Why can't we have a widely popular, not very intrusive, efficient regulation to deal with one of the biggest issues, illegal immigration? So that would be my sort of argument that, sure, this is a small additional regulation, but we have lots of regulations. Why would we not have a regulation that's not that intrusive for this very crucial issue?
A lot of questions, a lot of hands. I see everybody. Let me go in order here. Representative Warden,
Thank
followed
you.
by Pimentel.
And thanks for your testimony. Is there a cost to employers to use the E-Verify system? Do they get charged?
So I think the answer is there's a cost to everything in the sense that it's a additional layer of regulation, right? The regulatory burden, that $1.75 trillion, isn't necessarily, it costs our businesses $1.75 trillion, but it's a time thing. Someone's going to have to be on staff to submit everything, right, to deal with that. It's additional paperwork. So there is a small layer of regulatory cost there that is going to impact businesses, just like every other regulation that we put on businesses.
Follow-up? But by the current statute, the employers are already required to obtain documentation showing the employee's eligibility to work in the U.S., correct?
That's correct, but E-Verify is a common sense way to deal with illegal immigration. It's a streamlined process that most businesses already use, and we're one of the few states that does not have mandatory E-Verify. So this is essentially bringing New Hampshire's regulatory code up with this issue, up with many other states, bringing it to par. Does that make sense? Does that answer the question?
I want to say this correct. Pimentel? No, what is this? Sorry. How do you pronounce it?
Pimentel works fine.
Okay.
Pimentel, it
Okay.
depends on who you talk to.
All right, followed by Sullivan. Go ahead, Representative. Thank you.
Thank you, Mr. Chairman. Thank you for taking my questions. I noticed in your opening remarks that you gave a figure of, I think, 1.3 million illegal immigrants coming across the southern border. And kind of a follow-up on a question asked earlier, do you know how many illegal immigrants there are in New Hampshire?
So, Representative, that was 1.9 million illegal immigrants that entered the country from the southern border last year. And that's an estimate, of course, from Border Patrol. So we don't truly know the exact number. And how many of those remained in the United States? Excuse me. It's impossible to know with absolute certainty. But as you might know, about 50% of illegal immigrants come from folks that are overstaying their visa. So I would imagine that New Hampshire, there's nothing that I'm aware of that would make us out of whack with that national trend. So I don't know the exact number of illegal immigrants, but I think most people think the right number should be 0 in this state. That's what I hear from my constituents. They want us to move as close as we can to 0.
Sullivan, followed by Huff, followed by Toomey.
Thank you, Mr. Chairman. Thank you for taking my question. Could you explain exactly how E-Verify works and especially what the error rate is? For example, is my name in the E-Verify system to verify that I'm here properly and able to be employed? I'm concerned about someone who is eligible to be employed might get flagged by the E-Verify system for some reason. So please explain how it works.
Well, Representative Sullivan, thanks for the question. E-Verify works very simply the same way any other background check would work, which is conducted. I'm a landlord, for example, so when we screen tenants, we do a background check. And any background check can have an error rate. That's the way it works. It doesn't mean that we shouldn't conduct a background check or we shouldn't conduct E-Verify. So, of course, you're going to have false positives and negatives that are wrong as well. That just comes along with any background check system. So there really isn't that much to it. It's as simple as an answer I can give to you, sir.
Follow-up?
But you didn't really tell me how it works. You just said it's like any other background check, but is it a list of names of illegal immigrants? Is it a list of names of citizens as well as legal immigrants? How does it work?
Yeah, so let me try to be more specific, Representative. So all an E-Verify check is doing is running to see if someone's social security number is accurate, to see if they are a legal citizen in the United States. So they can check, so for example, if I was going through an E-Verify check, they'd say, okay, this is my social security number. Yes, he is a legal citizen of the United States. He's good to go. We're able to hire him. That's it.
You all set, Representative Sullivan? Huff, and then Toomey, and then I'll keep going after that.
Thank you, Mr. Chairman, and thank you, Representative, for taking my question. I was just curious, is this a private company, that E-Verify, or is it a government company? Who runs it?
Well, thank you, Representative, for your question. So an E-Verify check, you're doing a couple of things. So who's actually running the check, but then, so like processing it, but then you have to check and see if someone is a legal citizen. So you're using that social security number, and ultimately the government has that information, right? So you have to do both layers there, where you have to process it, but then you need the correct information. So I hope that answers your question, that it'd probably be a private-public partnership on that check there.
Thank you.
Representative Pimentel.
Thank you, Mr. Chairman. Thank you for taking another question from me. I'm guessing that this is not going to be that easy to implement, in that maybe you can tell me how this would work, but I get the feeling, just from what it is here, just like when we go to vote, every new employee is going to have an E-Verify no matter what. And that being said, how do we make sure that every employer actually E-Verifies every prospective employee? What is the check and balance here?
So Representative, I just want to get crystal clear on what you're asking. The question is, how do we make sure employers are in fact using E-Verify for every person they're hiring?
Yes.
Well, thank you for the question, Representative. I guess it's like anything else. I'm a little perplexed by the question. You're asking, how do we, like, if you have a law, which we have in many different instances, how do we make sure that every school is using a background check when we have people that are working with children, right? Of course, we would want a teacher to have a background check before they're working with little kids. How do we mandate that the school requires the background check and that they actually use it? It's not any different than that. So I'm perplexed as to why that is a concern. The same way that we have mandates on lots of other things. And Representative, if you want to ask a follow-up, go right ahead.
Thank you.
Well, because I'm just,
Can I
no,
ask a follow-up?
I said that because I just want to make sure that I'm answering the question for the members of the committee, but I'm going to
take a time out here.
Yeah.
Representative Callum, would you like to take your seat? Representative Mitchell, do you have a follow-up question?
Yes, Mr. Chairman. My question is basically a matter of fairness. I wonder whether or not people are only going to use E-Verify on their prospective employees who have an accent, for instance, and not every single employee that comes and applies for the job.
And that is your question to the presenter.
Yes, it is.
All right.
Thank you.
Well, thank you, Representative, for the question. Same as I was saying, if you were conducting a background check on teachers working with kids, regardless of someone's race, gender, age, you have to conduct the E-Verify check. It's very important. That's why it should be mandated, because right now, when we don't have mandated E-Verify, you're probably dealing with a situation where it's more likely that an employer might selectively run an E-Verify check. This law would bring it up to par, so all people that are being hired are subject to that E-Verify check, which isn't that intrusive, but it's done fairly to everyone.
I see only one more hand. Representative Menable, you're recognized.
Thank you, Mr. Chairman. Thank you, Representative, for presenting. As we know, RSA 275A has a penalty section of $2,500 per day for violations. So my concern about this amendment to 275A4A and the use of "and" between verifying through E-Verify and obtaining documentation suggests that, for example, if someone came in with what appeared to be legitimate documentation, such as a birth certificate or a social security card, and the employer did not proceed with the E-Verify system, they could be subjected to the penalties under 275A by virtue of having failed to do that if the documentation was not legitimate, not accurate. Does that possibility cause you any concern, or would you consider the idea of making them in the disjunctive rather than the conjunctive?
Well, Representative, can you clarify the question for me? What you're saying, you're saying if there's false documentation, meaning what exactly?
No, I'm going to interject here because we got to get this thing moving. You have "and" on line 5. So you want to E-Verify and all this other documentation. In our law, you have a $2,500 fine for violation plus $100 per person per day. The question, I believe, is, go ahead. Now I answer your question.
Thank you. Would that create potential liabilities for companies that did due diligence but not enough because they didn't pursue both avenues and were therefore subject to penalty for having failed to do one part or the other of those?
Well, thank you for the question, Representative. You know, I appreciate the concern, and I do think that this bill is a step in the right direction, because right now, if we have businesses that are not conducting an E-Verify check, but they do hire an illegal immigrant, and very well it could be by accident, not deliberately, they are potentially liable because of that. So this is a way for employees to say, great, I'm checking the box, I'm not hiring a legal immigrant, this is a step in the right direction. But I appreciate the concern, Representative.
I have one question. Can you please tell me how many states in the union you have mandatory e-filing requirements?
It's a majority of states. I don't have the exact number off the top of my head.
Any additional questions? Representative Avaloni.
Thank you, Mr. Chairman. Thank you, Representative, for taking the question. Would a business be mandated to verify employment even after obtaining documentation? Because to me, it seems that it's out of order as it's written. No employer shall employ any employee without obtaining documentation and verifying employment. Because you can't verify, you use the E-Verify system without obtaining the documentation. Seems a little bit out of order to me.
So Representative, every business has to conduct the E-Verify check for employees that they're hiring. That's what the bill does. Does that answer your question, Representative?
Thank you.
Seeing no other questions, thank you very much, Representative Baxter. I want the committee to know that Lexi Rojas is here from the New Hampshire DOL. I'm going to have her come up last after people could testify, and then you can follow with any questions that the committee has with her. Maggie Fogarty, American Friends Service Committee.
Thank you. It's counterintuitive. Good morning. My name's Maggie Fogarty. I'm with the American Friends Service Committee, a Quaker organization working on issues of immigrant justice and other forms of human rights around the world. And I'm speaking on behalf of the New Hampshire Immigrant Rights Network, which is a statewide coalition of organizations, individuals, faith leaders, attorneys who are working together for humane immigration policy, certainly at the federal level where immigration policy is set, but also as immigration-related issues impact our state and even municipal activities. And we're here to urge you to oppose HB 1124. This bill, as you understand, would unnecessarily require every single employer in New Hampshire, no matter the size of the business, to use the federal E-Verify system. I'm glad that the representative from the Department of Labor is here to answer some of the specific questions that you've raised already. I'm not an employment law expert or anything like that, simply an immigration advocate. The E-Verify program was enacted in 1996 with the purpose of curbing the employment of persons who aren't eligible or authorized to work in the United States. It's operated by the U.S. Citizenship and Immigration Services, USCIS, which cross-checks the information submitted by an employer with their own database of work authorization. Currently, 22 states, not a majority, 22 states have adopted mandatory E-Verify in the United States. You'll see the list of those states in the footnote of our testimony, which I will submit. However, despite even with 22 states adopting this, the rate of participation by businesses, even in those states, is very low. In 2018, the Department of Homeland Security had enrolled 821,771 employers, because you create an account, you log in E-Verify, amounting to 13.5% of all employers in the United States. So this means that 86.5% of U.S. employers refused to use E-Verify in 2018. Although the error rates have improved over the years, the E-Verify program has caused harm to many people who are authorized to work in the United States, but because of maybe hyphenated names, complex names, names that are frequently misspelled, they are deemed to be ineligible by their employer, with an obvious harm to the employer, actively seeking employees never more intensely than now, but certainly even more acutely to the family, relying on that income for their basic well-being. And again, that would be for harm done to authorized workers. In 2018, approximately 70,000 people received erroneous eligibility determinations. And over the life of the program since 1996, nearly 750,000 legal workers have been harmed. The time to challenge an initial determination of ineligibility is very short. It's only 8 business days. And some applicants are neither informed nor given an opportunity to correct an erroneous determination. We believe that the E-Verify program is not necessary because of the broad and heavily enforced requirement that all employers submit the I-9 documentations as well. So this would be an unnecessary overlay. We think that creating a more coherent immigration system in the United States where there are clear pathways and adequate resources to process people's visa applications, immigration benefit applications, is much more worthy of our energy than overlaying this system. Also, employers frequently misunderstand their obligations with regard to this program, and that increases their liability for penalties. So they could, as has been mentioned, only use E-Verify for those they perceive to be non-citizens, and that certainly invites a claim of racial profiling. They often use it to pre-screen potential employees, which is not an authorized use, and then the applicant never knows that they've been denied work for a mistake. And they are also in error when they fail to notify the employee when there's been a negative determination. And there aren't any due process protections written into the federal E-Verify law for an employee who is harmed. So for a state that understands itself to be business friendly, we don't see this as adding anything to the equation. All employers can use E-Verify if they so choose. So the letter I'll submit to you today is signed by 50 people who care about this issue. You'll see a diverse range of towns and of organizational associations. I'm happy to take any questions you may have or to just leave room for my colleagues to speak.
Representative Prout, you're recognized.
Thank you, Mr. Chairman, and thank you for taking my question. You mentioned that there was a limited time window to challenge a negative determination. Does the burden of challenging the negative determination fall on the business or on the individual?
It would be the individual who could, correct what they perceive the error to be, or to ask that the documentation be resubmitted in with a different spelling of the name.
Follow up. So they would have to work in conjunction with the business, so both would be involved, because the business would have to resubmit with a different name, so
That's
it would
right.
be a burden on both of them.
It would yes, but the primary kind of consequence of that erroneous determination is on the worker then, who wouldn't be able to either start that job or continue in that job.
Thank you.
Representative Cahill.
Thank you, Mr. Chair, and thank you for taking my question. Might an umlaut in your name make it difficult to correctly identify your status?
Yes, absolutely. I just purchased a plane ticket for my daughter. She has a hyphenated last name. We had to try 6 different times to confirm that she was in the system. And so that was just a hyphen. And an umlaut would be a good example of the kinds of problems that can surface.
Dankeschön.
Bitte.
I'm sorry, I guess I may not be up on things. What did you say could be a problem? What was the term you used?
It's an umlaut. It's 2 little dots above
Umlaut.
a letter to adjust the pronunciation.
Thank you. I learned something new. Any other questions, Ms. Fogarty? Representative Love.
Thank you for taking my question. It seemed like you were pretty concerned about false negatives, false positives and stuff. Would you find this bill a little more palatable if we put in a grace period, 30, 60 days, whatever, in order for somebody to defend themselves against?
The bill is not necessary. E-Verify is not necessary. The I-9 process is very thorough and comes with all sorts of weighty consequences for not complying. So E-Verify doesn't accomplish anything that the I-9 accomplishes.
Thank you.
Representative Seaworth.
Thank you, Mr. Chairman. Kind of follow up to that question. In terms of the federal requirements on E-Verify, isn't it the case that those the requirements are built into the federal system when you register, and no state law can waive those federal requirements?
So are you referring to a possible grace period, et cetera?
Right, if we wanted to mandate E-Verify, but somehow present a gentler, softer
Yeah,
version.
yeah. Well, that makes sense to me. I won't pretend to be an expert, but that makes sense to me that the program is already written as it's written.
Representative Sullivan.
Thank you, Mr. Chairman. Thank you for taking my question. I'm not an employer, so some of this stuff is new. I-9 is new to me. Could you explain in detail what the I-9 document is?
Yes, and I think I'll be smartest to defer to the representative from the Department of Labor, but as an employer, I utilize the I-9. It's a form you can download off of the, I don't know if it's which federal website it is, and it requires, there are 2 columns of documentation that prove someone's authorization to work. So if you have something from column 1, then you don't necessarily need something from column 2, but if you have a document from column 1 that doesn't necessarily establish your work authorization but shows your identity, then there would be a second column of documents. So it's a very standard part of any employment process. It's a one-page form.
Thank you.
I have a few questions, please. You said 22 states have enacted this law. Have any states repealed?
That's a good question. I don't know. It's underutilized in those states according to the data that we have.
Are there any New England states that have this law?
That's a good question. So the states are Alabama, Arizona, Colorado, Florida, Georgia, Idaho, Indiana, Louisiana, Michigan, Minnesota, Mississippi, Missouri, Nebraska, North Carolina, Oklahoma, Pennsylvania, South Carolina, Tennessee, Texas, Utah, Virginia, and West Virginia. So no states in.
In your testimony, you used the term humane immigration policies. Can you please explain to me what a humane immigration policy is, and do you feel this is not?
Yes, well, I do feel this is not. But humane immigration policies acknowledge the stories that connect so many of us to our family's pathway to the United States. It acknowledges that people are traveling, migrating for very wholesome reasons, from economic opportunity or love or safety from violence or from economic desperation in their own countries. And it creates a pathway where people can fill out an application, they'll understand the conditions, they get a timely review of their case. It's not policies that are motivated by for-profit prisons and for-profit surveillance companies, which drive so much of the enforcement behavior that we see and have seen for decades in the country, not just in the last few years. Humane policies would also acknowledge that when people come to our southern border fleeing for their lives, that we don't just close the borders, that we have processes where their cases can be heard.
All right, thank you. Are there any other questions for Ms. Fogarty? Seeing none, thank you very much for your testimony.
Thank you.
I'd like to call Eva Castillo.
Good morning, Mr. Chair, members of the committee. Thank you for taking my testimony. My name is Eva Castillo. I'm an immigrant rights advocate, lived in Manchester for many, 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 many years. I'm here to speak against this bill. I'm part of my organization. I'm the director of the New Hampshire Alliance for Immigrants and Refugees that works statewide, and we're part of a larger national coalition, and we're part of the organization that gave you the letter that Maggie just read and distributed to you. So I'm not going to repeat some of the stuff that you've heard. The fact is that E-Verify has not proven to work and to deter undocumented immigrants from working or from being hired. In states such as Arizona, that was the first state to enact E-Verify, the compliance is like 60% according to the Cato Institute. And what happened was that the wages were decreased for undocumented immigrants. So instead of deterring them to get employment, they just doubled up and they got additional jobs to supplement their income. This is not going to put a stop, and it's not going to employment of people that are here without authorization. The fact is that a lot of industries depend on the hard labor of undocumented agricultural, the meat packing places, and what are they gonna do without their employees? Right now we have a crisis with the pandemic. I cannot tell you how many calls I get every month of employers looking to hire people because they cannot find employees. So this is going to hurt the businesses. It's gonna put an additional burden on the small businesses that are already hurting due to all this COVID mess that we're into. It's gonna put an additional burden on them. It's gonna be costly for them because they're gonna have to assign a person to spend some time learning the system and using it. But it's not going to be effective for anything. It's going to subject the businesses to liability because a lot, and this is not only for citizens. A lot of non-citizens that are legal permanent residents, we work here. Before I became a citizen, like 20 years ago, I worked for 15 years or so as a legal permanent resident. And I wasn't a citizen, but I had the legal right to work here. So the names is another mess. We in Latin America, we use both our parents' names. So I'm Eva del Carmen Castillo Stephanie. This is my maiden name. And then when I married my husband, so it's Eva del Carmen Castillo Stephanie detergent. So I came here on a student visa in the 70s when they used to give us social security numbers, and that's still the social security number that I use now. But that had, I don't know what combination of my names previous to my married name. So it creates additional burdens. It burdens the businesses. It burdens the employees. A lot of employees that get kicked out of the system for something that they don't get notified by the company, because why bother? There's an additional step to say, hey, you know what, your application didn't come back correct. They're not going to bother, so these people are going to go without jobs. It can potentially, like I heard the representative said, it can pose an incentive for just plainly dismissing people that look or sound like me. Well, if I keep my mouth shut, I guess I could pass. But, that sound like me or that look different. So that could present a potential liability also. So for all those reasons and all the beautiful crafted letter that we put together and with all the reasons, it really makes no sense in New Hampshire to do this, to mandate that in a state whose motto is live free or die. We do not need one more regulation when we already have protections for employers and we already have a way to verify who's working here with what kind of documents. So thank you.
Thank you, Ms. Castillo. Any questions for the presenter? Representative Love.
Thank you for taking my question. Forgive me if I didn't understand you. Sometimes I have a hard time.
But accents can be hard.
Are you aware of the labor law violations, the safety violations, the health violations that,
Yes, I
that
am.
illegal immigrants have to put up with because they can't report? They can't
Yes.
report anybody to anyone. Also the strain on small business. I know for myself, about 15 years ago, I was in the home improvement business, and it was January. I was given a real cheap price, to rehab this building, and illegal immigrants came in and cut me in half. And the only money I was making is to pay my help so I wouldn't lose them. Okay. These guys, they don't have insurance. Most of them, they don't have workers' comp. Their equipment is. Do you realize that stuff goes on? And
I realize that because I am a board member of the New Hampshire Coalition for Occupational Safety and Health for over 20 years, and I volunteer for over 30 years to interpret at the Department of Labor the workers' comp hearings because they don't pay for interpreters. So I am boots on the ground, and I can tell you the horror stories of the abuse that people, the immigrant workers have endure just to keep a job. I have people that have had the employers sew the cuts. I have people that had cracked their skull and been in coma for 6-7 months with nothing. And we had to pack him and send him like a rag doll back home. I cannot tell you, I mean, over 30 years I've been doing this, so yes, I am very aware of the abuses that people endure in order to make a living.
Follow up, Representative Love?
So, if implemented correctly, wouldn't an E-Verify system help as far as the ability of an immigrant to be able to report an employer that's breaking all these laws?
The laws are going to continue to be broken, and the fact is that as long as we, like Maggie said before, as long as we have a subclass of people that are continue to be preyed upon because of their immigration status, these people are going to continue hiring them and abusing them, and workers have no other choice than to work. The solution is not to put more barriers to employment, because people already are in dire need to find employees. The solution is to pass a humane immigration reform that would allow the people that are here without the proper authorization to earn a decent living.
Thank you.
Thank you.
No questions. Thank you very much for your testimony.
Thank you very much.
I'd like to call Bruno de Brito, New Hampshire Brazilian Coalition, to testify.
Good morning, Mr. Chair. Good morning, members of the committee. My name is Bruno de Brito, and I am an immigration advocate in the state of New Hampshire. I am president of the New Hampshire Brazilian Council, and I am an immigration attorney. I would like to start by giving a little bit of background on immigration law. So the first time that the United States really started requiring and prohibiting other people to come to the United States was through the Immigration Act of 1924 that excluded certain individuals from coming into this country. But the law wasn't really established until 1929, which that was when the Border Patrol was established. Today, that department is under the Department of Homeland Security, known as Customs and Border Patrol. So these individuals that came prior to that, if we apply today's immigration law, these individuals would be called, or like some people state illegals. Some of them would be deemed to have been called asylees, which is someone who files for an asylum application. And thankfully, to the Constitution of the United States, you would be, the babies granted U.S. citizenship through the 14th Amendment. It is my opinion that this bill is in violation of the Constitution. The reason being is because the state doesn't have the power to enforce federal laws. The 10th Amendment states that all the power that has been granted to the federal government by the Constitution or by federal law shall be deemed in the hands of the federal government. All the other powers should be given to the states respectively and to the people. So this law is a federal law that the state of New Hampshire is trying to pass. And some of you, I bet you're thinking, oh yeah, but we have 22 states that have passed this legislation. But none of these states, the law has been challenged yet. So we don't know for sure the constitutionality of this law. So also, as business owners, I know some of you are, do you really want the state to interfere with your ability of livelihood, telling you what you should and should not do with your own business as a business owner? As I have stated, like immigration has not been changed much. Immigration laws has not been changed much from many, many years. And unfortunately, it hasn't followed the current moment that we're seeing. As you all know, we have a lot of employers that want people to work, but they cannot find anybody. And I can speak to you from the immigrant community. They're scrambling to find jobs, because in the immigrant community it has been so difficult for them to actually get jobs, because the typical jobs that immigrants perform are the jobs that no Americans want to do: cleaning toilets, constructions, plowing snow, landscaping, and so forth. So it is very, like difficult, especially during the winter, during COVID. A lot of families are struggling to find jobs because of many circumstances out of their control. So, in addition, we have many, many, many what we call mixed families, which someone in the family, either the father or the mother, most of the time the father, that is undocumented. We don't use the term illegal. So the term illegal, so you all understand, is the equivalent to the N word. So we don't use that term. So the father is typically undocumented. The mother is a U.S. citizen, and they have a U.S. citizen child. So if the father is not able to get work, the mother has to take care of the child, who's going to pay the bills. The mothers typically, especially immigrant families, they don't like to seek out for help, even though they have a U.S. citizen, because they're always afraid that it might have a consequence on the undocumented immigrant in the family. So it is a very complicated situation. Immigration is not easy. I'm sure you all see the calls for immigration reform in the news pretty much every day. It's because it's so convoluted. Not even us immigration attorneys really understand it, because it changes daily. So it's hard to keep up. But I urge you to vote against this bill. Thank you.
Thank you for your testimony. Are there any questions for the presenter? Seeing none, thank you. I'd like to call up Rasha Mahmoud. Mahmoud.
Good morning. Greetings, Mr. Chairman, members of the committee. My name is Rasha Mahmoud. I reside in Derry, New Hampshire, and I'm a member of the public. I'm here to oppose HB 1124, and I'll tell you some of the reasons why. But first, I want to reinforce the idea that it's no longer acceptable to use the term illegals. It's not in the text of the bill, from what I've read. I see undocumented, that's an acceptable term. But I heard a gentleman earlier testifying using this term, and illegals is not acceptable at a time when this country is going through a racial equity reckoning. Also, people that are undocumented can become documented with some federal immigration reform. So let's retire that term. That's my first point. Secondly, I want to say that this bill is bad for people, for families, for livelihoods, and for communities. I'm the head of a household of a mixed status family that Mr. Bruno referred to. So I'm a U.S. citizen. My husband immigrated here several years ago on a student visa, and we've been trying to change his status from a student to a legal permanent resident for about 2 years now. And during that time, we've had a child, and our baby is now 1 year old, and we're still waiting for his work permission. We're still waiting for a green card, and that means that he is undocumented. He doesn't have status. But does he have a right to be here? Of course he does. He's also a young man who's ready to work. He's young, he's able-bodied, he has great skills, he's educated, and there's not a possibility for him to work right now. I expect that he'll go through a background check when it's time for him to get hired or when he finds a job, but I can't understand why it would be necessary to perform a background check that requires reporting him to the federal government. Finally, I want to confide kind of personally. I'm the sole provider at the moment. I'm a mom. I work 9 to 5, and occasionally we have to send our child to daycare. With not having status, people in New Hampshire also have a hard time getting a driver's license. So to add on top of that difficulty of not having that extra financial support from my husband, he also is not allowed to drive. So you can just imagine all of the stress and financial burden that falls on women like me. It's like being a single parent in some ways. So he's just been undocumented and waiting for 2 years. Other families have been waiting for much longer to get status here. Why should we take away people's livelihoods if they're already here? Do we want to see families suffer? I don't think so. There's job wanted signs everywhere. My husband can't apply for any of those jobs. And so services will go unprovided, and the economy will subsequently be affected even more by this pandemic. So why should we make it more difficult to hire employees that want to work? Finally, I think that it's important that we leave enforcement of immigration issues to the federal government. And perhaps one of the solutions to this problem is reforming our federal immigration policies and making it easier for people to immigrate legally, including, pathway to citizenship for undocumented people and holders of dreamers, TPS, refugees. Let's be proactive about immigration rather than reacting in this way. So until our immigration system is reformed, I think there's a better way, especially in a live free or die state, rather than putting more restrictions. So I'm urging you all respectfully to oppose this legislation. Thank you.
Thank you for your testimony. Are there any questions for the presenter? Seeing none, thank you for your testimony. Last card I have, Lexi Rojas, New Hampshire DOL. Ms. Rojas, I think do you have any testimony or you just want to answer questions?
I just wanted to announce myself that I'm present for any questions that anyone's available, that everyone has. The department has no position with respect to the bill. We understand it as written. We do find it would make it easier for us to enforce our statutes, but we are here for questions.
Representative Avalani.
Thank you, Mr. Chairman. Thank you to the DOL rep. Could you explain to us how the hiring process works for employers? Employers are required to get I-9. Employers are required to file with the state within a certain amount of time. And if the process isn't met, what happens to those employers when they're found under audit?
So they're not required to file it with the state. They're required to retain it in their possession for the duration of the employment and an additional 3 years. So during an audit, we would ask the employer to present the documentation, the proof of the documentation to work, the I-9s, and then we would look at it and just make sure that they had it on file. And if they do not have it on file, the employer is subject to up to $2,500 penalty. So it's not an instant $2,500, but up to $0 to $2,500, plus an additional up to $100 per day per employee for the duration of the violation. Usually the duration of the time that the work was done. Most of the time we come up upon this situation is construction. That's where we're seeing an issue with undocumented workers or fraudulently documented workers. And they are often paid less than the documented workers, and we are seeing less protections for them, as previously testified.
Follow up.
Thank you. So when you come across that undocumented workers with fraudulent documentation, the employer is responsible for that, for taking that fraudulent information and hiring them as employees?
That's tricky. So the issue is, and I'm not sure if E-Verify is going to be the answer either. So, we understand the law, because we come upon it, is the employer is not expected to be an expert in the documentation, but they are subject to potential penalties if it was so obviously fraudulent that it was, it errs on the side of negligence. The pictures don't match, the date of births are off, the font's weird on the fraudulent documentation. So I think, it's our understanding from E-Verify that it may take some of the mystery out of it for the employer, so that they're not entering into that liability, that questioning on us, on our part. It adds an easier step of due diligence where we did have one recently where the pictures just didn't look right. Everyone looked like they had glamour shots in the documentation that we saw. That it takes some of the, so the deciding factor upon the department is whether or not we're going to try to hold the employer accountable. Should that employer have known better from their review of the documentation? Now, E-Verify, I don't believe would have. I think it's it's a government-run website in which it would be an easy check for the employer to determine whether or not the documentation is fraudulent or not.
Follow up.
Thank you, Mr. Chairman. Unemployment Securities requires us to file with them within 2 weeks of hiring a person. If that information comes back.
Sorry, I wasn't aware of Employment Security does. So Department of Labor doesn't require filing with us. So I wanted to clarify that.
Yep, I know.
Thank you.
Employment Securities requires two weeks for a new employee. What if that information comes back as an employer issue, took the wrong information, again, fraudulent issue, the DOL walks in the door and does an audit on that employer because ES flagged it? How does that work for the employer?
So if the employer knew it was fraudulent and continued to operate, so that would be a question for us to determine through, and it would be through the investigation whether or not the employer should have known. If they continued to operate after Employment Security flagged it for them and informed them that it was that the documentation was fraudulent, and it would go through the hearing process if we couldn't reach an informal settlement.
Representative Turcott. Thank you. Are there any other questions for Ms. Ross? Seeing none, thank you very much for your testimony. I do not have any additional pink cards. Are there any additional individuals who would like to speak on this legislation? Representative Cahill, you have a question of the chair?
Yes, actually, it's for Mr. Avalani. If he would please move the microphone closer, because I'd like to hear his questions, because they're always very insightful. Pull it up a little bit.
Thank you. I will do my best. Seeing no questions, the hearing on House Bill 1124 is closed, and we will immediately open House Bill 1165, which do not have any pink cards whatsoever for anyone who would like to present the bill or not. So get on it. My mother's mad at me because we're not on time.
Do you need me to, if you have to leave in 10 minutes, you need me to do this?
I do. I'm just opening it up here for you. Whatever, there's that, you got everything.
So this is,
1165, got it open for you.
all right, all right.
The vice chairman will be stepping in while I go testify against a thoroughly ridiculous bill.
Thank you, Mr. Chairman. The chair recognizes Representative Prout to introduce his bill.
Thank you, Mr. Chairman. I am Andrew Prout, representing Hillsborough County District 37, the towns of Hudson and Pelham. This bill would repeal the Granite State Family Leave Plan that was inserted into House Bill 2, the budget trailer bill, last year. As we all know, the budget process last year introduced many policy changes, and I disagree with this one. While the program was sold as a voluntary private insurance plan, it is 100% taxpayer funded for the 11,000 state employees covered by it. This cost is not guaranteed to stay within the rosy forecast predicted by its proponents, and the taxpayers will be on the hook for the increased costs when the contract comes up for renewal. Private insurance similar to this offering is already available and costs much more. This will also affect county, municipal, and school budgets. You may look at the bill and what passed in HB2 and think that you don't see where it does that. But it should be obvious that an unnegotiated free gift to state employees will not go unnoticed by county and local government employees. This program will metastasize, and then it will grow as previously stated. Local governments will be left holding the bag. When the costs on this program increase, not if but when, there will be calls to make the program mandatory, to explain away these increased costs by selective enrollment. I predict the insurance companies issuing contracts under the state program will be at the forefront of these arguments. What better way to drive more business to them? Unlike how other states have implemented this idea as a government-operated program, we've set the stage for crony capitalism. We've set the stage for an army of lobbyists and campaign contributions to make sure the program never changes, is never reformed, and the overhead costs pocketed by these companies are never audited. We don't need programs like this for companies to offer great benefits to their employees. We're in one of the most severe labor shortages. Companies are offering a myriad of incentives to hire and retain employees. Some do this with better benefits, some do it with higher base salaries. It varies from industry to industry and employer to employer, as it should. Government involvement will only make the situation worse, as I've experienced myself. I work in Massachusetts, where they've recently implemented a family medical leave insurance program, and my work decided they couldn't meet the new requirements on minimum accrual rate, tracking usage, and all the other regulatory burdens under the new terms of the new FMLI plan, which they actually had a waiver from because they already had a similar benefit, but not from the reporting requirements. So to meet these new rules, they reduced the sick leave benefits available to employees that had been in place for decades. A real-life example of making things equal in the way described in Kurt Vogelnutt's story, Harrison Bergeron. As we all know, once the program is implemented, the chance of a repeal becomes unrealistic. It will only grow, like all government freebies. The time to address the problem is now, and thank you for your time and consideration, and I'd be happy to take any questions.
Any questions for the representative? I have one. Do you have any information on the status of implementation since this went into the budget bill? What has happened at the state level so far?
Thank you for the question. I do not know precisely where the Department of, I think it's Insurance, is in issuing the contracts. I know they have begun discussions, but I also know that the contract has not yet been issued, and I know it has not yet been gone to the Governor and Council for issuance.
Thank you. Any other questions for the representative? Yes.
Thank you, Mr. Chairman. Thank you, Representative. I'm just wondering, I wasn't really part of the sausage making on HB2. I'm wondering, do you have any historical knowledge of just how this made it into HB2?
Thank you for the question. I can tell you that it was not in the version of HB2 that left the House, and it was part of the Senate hearing process that inserted it, and then in the committee conference, it was, I believe, one of the last items to be decided to retain in there.
Thank you.
Further questions? Seeing none, thank you very much for your testimony.
Thank you.
Next up, I have a card from Amanda Sears. She is representing the Campaign for a Family-Friendly Economy.
Okay, thank you. Getting back into the habit of this, sorry about that. So good morning, my name is Amanda Sears. Can you hear me all right? Okay, it's muffled. I'm the director of the Campaign for a Family-Friendly Economy. Paid family and medical leave is important for workers and businesses in the economy. And the COVID-19 pandemic has only underscored the value of having a system for ensuring people can take the time they need for medical emergencies without putting their financial security at risk. But the governor's program to artificially prop up a private insurance provider is not an effective paid leave program that meets the needs of Granite Staters. What the legislature should do here is repeal this program and replace it with one that covers all working people. So we would be in support of an amended version of this bill that would repeal and replace the program currently in statute. As a result of having no public hearings surrounding passage of this program, there are many problems with this program and many gaps in information about access, cost, implications, et cetera, which should really be considered. The governor's program entirely leaves out a path for employees at companies with less than 50 employees to access this benefit if their employer doesn't choose to offer it. And about 40% of New Hampshire workers are employed in these settings. These employees are already far less likely to have access to paid leave and are left out of the individual market entirely unless their employer decides to opt in and cover the whole staff. If they do, that employer gets the competitive advantage of saying they offer this benefit and they'll enjoy a publicly subsidized rate and/or tax credits, but they don't have any disincentive to deny employees from taking leave when they need it, and they can retaliate against or fire employees who try to take this publicly subsidized benefit. There's also a bunch of questions about people who work for multiple employers, and if you work for one employer of over 50 and one employer that's smaller that doesn't qualify for the individual market. And I think that, that might open the state up to legal challenges about discriminating against residents' ability to access this publicly subsidized program because of the size of the company they're employed by. The insurance companies have a lot of control with this program over cost of premiums, rate setting, denial of claims, and there's no process outlined for appeals of denied claims or even jurisdiction indicating who would be responsible for those appeals. And private insurers already control so many of our healthcare decisions. We would now be trusting them to decide when and whether we can provide care to our loved ones with this program. There's no consideration in this policy about the several operational questions, like if an employer purchases independent coverage for medical leave, but the employer fails to grant the employee time off? Or what if the employer recognizes the need for time off, but the independent insurer denies coverage? How are these disputes resolved? The state would be acting as a collections agency for this private insurer that's chosen. And I've not seen any legal opinions on whether it's okay for the state to charge low-income people in the individual pool the same premiums as high-income earners. but to provide them with significantly different benefits. Because how this would work is that, you know, somebody who's a $130,000 a year worker would pay the state up to $5 a week, the same amount that a $12 an hour worker would pay. But these two people would get wildly different benefits based upon what their wages are. There's also a bunch of other questions I probably don't have time to get into, but could answer if you bring them up. And then this is going to have a significant revenue impact for the state that hasn't been considered, and that are not based upon a consideration of how many people will actually newly get this benefit. You know, if we had 30% of employers in the state take advantage of that, that's about a third of our workforce. A third of our workforce already has access to this benefit. So you could have a third of our workforce take advantage of it, take a $30 million hit to the state budget, and not have a single new person have access to this benefit than has it right now. So the bottom line is, the reason that there's been a demand for state policy for paid leave is because 2/3 of working people don't have it. And there's significant disparity between who has it and who doesn't. And the people least likely to have paid leave are working people with the lowest incomes and the most significant caregiving responsibilities. Public policy should be used to eliminate that disparity. This does not guarantee that we do that. It doesn't make a commitment to ensuring that working people who have paid leave will have paid leave when they need it. And it artificially props up a private insurance market without making any commitment to ensure that people can take the leave that they are paying for with this program. I'll take questions. Thank you.
Thank you for your testimony. Are there any questions? Seeing none, thank you very much. I only had 2 cards submitted for testimony. Is there anyone else present who wishes to testify on this bill? Seeing none, I will close the public hearing on this bill. We have our next public hearing is scheduled for 11:45, so we have just shy of a half-hour break before we resume.
Thank you, Mr. Chairman. Representative Brian Sullivan, representing Sullivan District 1, Grantham, Springfield, Plainfield, and Cornish. I'm here to open the hearing on House Bill 1304, which is establishing a committee to study the impacts of outdoor working conditions in heat and cold. And that's all I got to say.
Were you planning on testifying on this bill? All right, thank you. Members of the Legislative Committee, seeing that there is no one else here to testify on behalf or against House Bill 1304, I'm going to close the hearing without objection. All right, thank you very much. We'll see you at 1 o'clock. The Republican members of the caucus, please meet in Len Turcotte's office at the end of the hallway, please. 300. Yes.
I can't hear you.
Right now.
Folks, I was just informed that apparently the representative apologized for not being here. She has a medical emergency, so she didn't blow us off. but I always had to eat, and she always wants to make sure I eat, so. All right, ladies and gentlemen, it is 1 o'clock. It's time for House Bill 1337. Opening the hearing on House Bill 1337, I call the sponsor, Representative Turcott. You're recognized to speak on your bill.
Thank you, Mr. Chairman, members of the Labor Committee. Excuse me. My name is Representative Len Turcott. I represent the town of Barrington, which is Stratford County 4th, third term in the State House. I'm currently a member of the Labor Committee, as you all know. I'm also on Finance 2. I'm on the Redistricting Committee. I'm also a senior advisor in the House Majority Office. I'm here to introduce House Bill 1337 on behalf of myself and the other members of the House Majority team who are co-sponsors to this bill. What this bill will do in a nutshell, it will tie unemployment duration to an unemployment rate. That will get folks back to work on an average twice as fast. It'll strengthen the state's trust fund over time. And over time, it will or should reduce taxes on businesses, allowing those businesses to either increase pay, expand benefits, or expand their business. The way this bill will work, it will index the amount of time on unemployment, collecting unemployment insurance to the current rate of unemployment in the state. The bottom number on this will be any time that the state's unemployment rate is below 5%. The unemployment benefit will be 12 weeks, which just happens to be at this point of time, 12 weeks is the average that an individual is on unemployment. An additional 1 week will be added for each 0.5% increase in the unemployment rate, up to a maximum of 20 weeks. Again, common sense legislation. The unemployment benefits should last longer when unemployment rates are high, and they should be lower when unemployment rates are low. Over time, as I mentioned, this will increase the solvency of our trust fund. A lot of the good model states, in this case Florida, I sent you all a extensive white paper on Florida, and their results, North Carolina and Georgia, are 84% more solvent than the standard states. Interesting, in that paper I sent you to Florida, when they first implemented this reform, their trust fund was in the hole by $1.7 billion. It's currently at $3.9 billion, a net increase of a $5.6 billion swing, and their unemployment insurance rate is about the lowest in the country at 0.1. A couple of things this will do. Not only will it help businesses, but it will help individuals who are unemployed. It's more likely that when individuals are unemployed, they fall into a longer-term dependency, and it becomes harder to find work. And that studies have always shown that receiving the unemployment benefits for an extended amount of time can reduce unemployed workers' job search efforts, decreasing their likelihood of becoming reemployed. I think we've seen over the last 2 years an excellent example of what happens the longer that you give individuals unemployment, the longer they tend to stay on unemployment. We saw this particularly last spring when the federal government was still handing out $300 a week unemployment checks, and they asked Governor Sununu would he continue that unemployment check of $300 a week, and he said yes. It was a very short period of time, a couple weeks later, that he reversed that, and that was because a lot of the business groups said, hey, we can't find employees. We need that to end. And by reducing that, you can see where we are today in the 2% range for unemployment. As we were just talking about, we are suffering a worker shortage at this time. We need more workers, not extended welfare or unemployment enrollment. The last numbers that I have show that as a total percent of Wages, the unemployment tax rate in New Hampshire is 0.47, which is good, countrywide. But you compare that to Florida at 0.1, that's almost 5 times less. Georgia is currently 0.22, North Carolina 0.39, and even Maine, who is not doing an indexing at the time being, is slightly below where we are. There's a couple word changes that I will be introducing amendment on later, and that those were recommended by the Deputy Commissioner, and I didn't want to put that forward now in case there were any other changes that may come forward. Basically, it was just some clarification on the second paragraph B, where we take the snapshot, how we take the snapshot, and the wording there. So in closing, again, this is rational, responsible, common sense legislation, shorter term payments when unemployment rates are high, and longer term payments when unemployment rates are high, and shorter when they're low. Ultimately, this will save businesses unemployment insurance taxes. Those can be used for the benefit of employees or expanding businesses. And as we said, we learned during the last couple years that a segment of our population tends to remain idle when monthly payments in New Hampshire at one time hit a high of $3,600 a month. And the final point I'll make is there is no financial downside to this, fiscal downside. There's only upside for this. And with that, I'd be happy to take any questions.
Representative Warden, you're recognized for a question.
Thank you. Maybe you're going to address this in amendment, but in paragraph 2, line 10 of the proposed bill, you say how to identify or define the state average unemployment rate. And the way I read it, it looks like the 3 months for the most recent third quarter. So it's quarter 3 of the calendar year, the average of those 3 months means you can only adjust it once a year, correct?
That's correct. I'm sure Deputy Commissioner Lavers will be happy to come up and explain exactly. As I said, that starting on line 10, we've discussed this, and he suggested a couple changes to that. When he comes up, if you would ask him that question, he will be able to answer it very well.
Follow up. But just as a follow-up, what was your intention?
Say that again?
What was your intention?
Once a year. Is that what you were asking? Yeah.
Representative Cahill.
Thank you, Mr. Chairman, and thank you, Representative, for taking my question. Is the economy, the employment rate, doesn't that sort of, it's a standard rate, which we say would change it once a year, you know, if they measure the circumstances once a year, but I think the economy sometimes moves more often than that. And furthermore, I wonder if the economy is the same for every sector of the workforce. There may be people in one field for which employment is very hard to come by, or in another region of the state where jobs are kind of scarce or more plentiful. What would you say to that?
I'd say we need one standard rate. We can't be putting together hundreds and hundreds of rates throughout the state of New Hampshire.
Follow up.
Thank you. Yesterday I sent out some material concerning the trust fund in our state, and I wonder if you might tell me how New Hampshire compares with all the states that you listed, that some of them have enacted this, and where we fall in that. And further, there were some issues that affected our trust funds, such as the governor opening up unemployment to people who were self-employed, a major decision that did affect our trust fund. While it was a good idea, it saves the economy, I just wonder, like, if things like that hurt the trust fund, would you prohibit that in some way going forward?
I will let Deputy Commissioner Lavers speak to the state of our trust fund right now. I am not an expert on that, so I have no answer for you on that.
Thank you.
You're welcome.
Representative Sullivan.
Thank you, Mr. Chairman. Thank you for taking my question. Could you explain your rationale? If I understand this correctly, the maximum number of weeks would go from 26 to 20. What is the rationale for doing that?
Say the last part, I'm having a hard time hearing you with the mask.
Sorry. My understanding is this bill takes the maximum number of weeks of unemployment from 26 to 20. What is the rationale for that?
Just off of other states' model legislation, simply that.
Representative Adejan.
Thank you, Mr. Chairman. Representative Turcotte, for context, I'm looking at an article right now from Business Insider that is titled, President Biden gambled that cutting off federal jobless aid would drive people back to work. The September jobs report blew a hole through that idea. Can you tell me the workforce participation rate from Governor Sununu saying that we were no longer going to participate in the $300 a week benefit program and the following workforce participation rate, and did people go back to work or did these jobs get filled after that change?
Without looking at that article and looking over all the numbers, I can't tell you off the top of my head, no.
Thank you.
I have one question, if I might. Want to keep things apples to apples. New Hampshire normally has a lower utilization of workers' compensation weeks because we have the lowest reimbursement at 60%, or versus that's what was workers. Yeah, sure. I was thinking workers' comp for a second. Sorry. We pay very low. Is there any? You sent us some good stuff on Florida. Are we comparable to them from a standpoint of what they pay in compensation? Because I'm just trying to have an apples to apples as to.
In addition to Commissioner Lavers, we'll have somebody else testifying here shortly who is very familiar with those numbers. So,
sure, excellent. Any other questions for Representative Turcotte? Seeing none, thank you very much. You're welcome to sit here.
Thank you.
You can't participate, or you can sit there, whatever you'd like.
Understand.
I have a couple cards here. Deputy Commissioner Lavers, do you want to speak now, or do you want to kind of at the end, or how would you like to go about this, sir? I'll have you do both. I'll have you speak first, and then you can follow up at the end if there's any misunderstandings or concerns about things from other speakers. Deputy Commissioner Richard Lavers, New Hampshire Unemployment Securities, thank you for joining us.
All right, thank you, Mr. Chairman. I did have a couple of things to hand out to the committee. This new layout makes that very difficult. What I can do is I'll get two piles going around so folks can have that to refer to. One of them is just a one-pager on our response from the U.S. Department of Labor when we submitted the bill for their review for compliance and conformity purposes. And I did have one other handout that was much prettier with pictures, not necessarily for what I'm going to talk about today, but just more of a reference point for the members to look at. And it's some materials that Chairman Infantine that we had talked about at the last advisory council meeting. So wanted to make sure the members had that.
Yep. I believe didn't you email this to the committee as well? I know I've seen this.
I think you might have emailed a portion of it, and some of this is updated. So. All right, thank you, Mr. Chairman. Just for the record, Richard Lavers, Deputy Commissioner of the New Hampshire Department of Employment Security.
Send all the extras over here, Mike.
And just to, before getting into my comments, the department understands, appreciates, and is really understands that long-term unemployment is not good for anybody. It's not good for the individual. It's not good for the economy. The first 10 years or so of my time with the department, I focused my time on reminding people that we were not just the unemployment agency, reminding folks about our reemployment services and all of the work that we do around training and working one-on-one with individuals to try to get them back into in-demand employment. And then I spent 2 years only dealing with the unemployment program and probably defeating all of that prior work. So we appreciate the fact that long-term unemployment is not good for any of the individuals that we work with. But right-sizing the unemployment program is important. And by right-sizing the unemployment program, referring to making sure that there are sufficient benefits available for individuals seeking in-demand employment, which might require new training and entering a new sector. I think employers in this state and individuals certainly have an interest in making sure that individuals are able to afford to be able to obtain that type of training for in-demand employment, if for no other reason that they are not coming back to the agency on a frequent basis looking for unemployment benefits again because they went into a sector that had a lower prospects for job growth and those jobs disappeared. So we want to make sure that it's right-sized so we're able to lower the number of times an individual has to come over and visit us and file an application for unemployment benefits. So that all being said, as is customary with policy matters coming before the committee, the department does not take a position for or against this bill, but we did want to talk about some of the mechanics of it. When Representative Turcotte had indicated that we've had some discussions about the mechanics, and then also wanted to talk about some related issues as well. I'll be referring to some notes just so I don't screw up with some numbers here, but certainly available to answer questions from members as well. So mechanically, as I understand the intent behind the bill, what it's seeking to do is to base the number of weeks of unemployment that are available, to tie that or to index that to the average unemployment rate, the total unemployment rate, over the third calendar quarter of the prior year. So when we think about the monthly unemployment rate, that is not a number that New Hampshire Employment Security publishes or is responsible for. We have a cooperative agreement with U.S. Department of Labor and the Bureau of Labor Statistics where that is issued out to the state by Employment Security. But the monthly unemployment rate itself, that is calculated by the Bureau of Labor Statistics. They do that utilizing the Federal Household Survey. They survey a sample of households in New Hampshire between 12 to 1,300 households. That is a point-in-time survey. They do it during the week of the month that contains the 12th. And from that survey, they then calculate their estimates for the number of individuals in the labor force. Either you're employed or you're unemployed. And in order to count as unemployed, you need to A, not be working, and B, actively searching for work and have actively searched for work in the prior 4 weeks. So that survey is conducted by the federal government. It is their survey. It's not something that Employment Security is out there calculating on a monthly basis. So I just want to make sure that mechanically we understand how that rate is calculated. According to this bill, we would take the average of the total, or what we would recommend using the total unemployment rate, which is that number that people are most familiar with that is published each month. You'd average that from the prior third quarter, and that would be the number that would be controlling for the following 4 quarters. If that rate were at or below 5%, the number of weeks available would be 12, and then for every half point above 5%, the bill would add an additional week up to a maximum of 20 weeks. There are, Representative Turcotte and I have discussed this, there are a couple of opportunities when the rate that is first published, that it subsequently is revised. And because of that revision process, we had made a recommendation on making sure to use the benchmarked rate. And by that, I mean when a rate is first published, so tomorrow, the U.S. Department of Labor will be publishing the national unemployment rate for January. Later on this month, in a few weeks, we will publish the January unemployment rate for New Hampshire. Now, when we publish the January rate, we will also update and revise the prior month's rate. So you'll see us in the press release that goes out, you'll see the January rate, and we will also, there'll be a quick reference saying, and the December rate stayed at 2.6% after revised, or the December rate was adjusted to 2.8% after revision. So you have that first opportunity where you, the rate that was first published is subject to a revision in that following month. And then at the end of the year, we go through a benchmarking process that is concluded in February of each year. So that's something that's ongoing right now and drawing to its conclusion. But benchmarking is a process by which we take the survey-based estimates, which were published each month for the unemployment rate during the year, and we compare those against the actual quarterly tax and wage reports that employers file. When they come to Employment Security every month and they tell us how many people they employed and how much they paid them, so that is compared against those estimates, and then each February we then publish the prior year's rates as benchmarked rates. So those would then be the final rates for that prior year. And I walk you through that process so that we can better understand when we talk about using the benchmarked rate, you would want to use that final rate and not something that was subject to movement. And because of that, and because the process is not completed until February of each subsequent year, mechanically how I would see this bill working is that once that was complete in February, then starting in the second quarter, you would be using the prior year's third quarter average as benchmarked. And then you would use that number for the second, third, fourth, and first quarters, and then we would do it all over again using the benchmarked rate for that prior year's third quarter. So it would control for 4 quarters, but it wouldn't be a nice, neat, and clean, orderly 1 through 4 of the calendar year. It would be, you would be doing it starting in the second calendar quarter, 2, 3, 4, and then that first calendar quarter, and do that process all over again. In looking at information relative to the bill that you're considering and indexing, our recent, well, first and foremost, our unemployment rate right now is at 2.6%. Prior to the pandemic, right before this all starting, we were at 2.6%, and we are now back to 2.6%. Our recent historical high prior to the pandemic was back during the Great Recession when we hit 6.7%. That was in November of 2009 through January of 2010. That was at a time period when the national rate was right around 10%. New Hampshire maxed out at that 6.7% during that time period. And then prior to that, back in the early 90s, 1992 specifically, we had hit 7.4%. So that's kind of some of the perspective on where our unemployment rate has been, where some of our high points have been. If the formula that's proposed here in the House Bill 1337, if that were in effect right now, we would currently have 15 weeks available. And because even though I had just told you we're at 2.6%, because of going back and using that prior year's third quarter, you would have the number of weeks dictated by what that average was for that third quarter, and that would be our 15 weeks. One this point of comment on the unemployment rate itself. The unemployment rate is what we refer to as a lagging economic indicator. So it doesn't tell us where we are right now. It tells us where we were in that prior month, in that week containing the 12th of that month when that survey was conducted. And that's an important consideration when we get into talking about how some other states that have variable duration unemployment benefits, like proposed here, some of the factors that they take into consideration on how the number of weeks available change. As I had indicated, right now, with our rate at 2.6%, we would have 15 weeks available according to this bill. However, if we went back to the second and third quarter of 2020, because we'd be indexing and then we'd be tying ourselves to 4 quarters, during the second and third quarters of 2020, which is a time period I've tried to forget. It was a very difficult time period for us all, certainly for the folks at Employment Security, with the unemployment rate having gone to 16%. But the number of weeks available during that time for state unemployment would have been 12. So that's some of the issues that you can see when you're utilizing a lagging economic indicator. Depending on how long you're going to use it, a changing economy could still be subject to controls that were put in place prior to those, in that case, some significant changes. And that's a point that's made just so that as you're looking at this bill and trying to make sure it's fits well into what we need here in New Hampshire, perhaps there's consideration for some flexibility on how long that indexed rate from that third quarter, how long it controls the duration, and perhaps there's some sort of statutory shutoff switch that can be temporarily implemented to try to right-size the duration of benefits for what you're experiencing at that point in time. So looking at our current statute with currently 26 weeks being available, this has been the case since 1951. So an individual coming in and filing right now, if they have a qualifying separation, if they have sufficient earnings from their base period, they would qualify for up to those 26 weeks, and those 26 weeks would be claimed over a 52-week period. Now, we do allow, in New Hampshire, we do allow someone to have part-time work while collecting for unemployment. And I point that out because individuals who do have part-time work and are collecting partial benefits may collect longer than 26 weeks. And those individuals have to have a qualifying separation. They have to be determined to be unemployed or have a reduction in employment through no fault of their own. But an individual who's not working, they cannot collect more than those 26 weeks during that 52-week period. But an individual that has part-time employment they could be having a partial benefit. So maybe they qualify for $300 a week, but their partial earnings bring that benefit down to $200 a week. They could be collecting for a longer period of time. However, I think both of those examples, both the person who's not working and the person who's working part-time, would both be subject to the durational limit based on the index here. So the 12 weeks or whatever that is as indicated by the prior year's third quarter average. Now, an individual that's working part-time, you've heard from me before on this, they are only allowed to earn up to 30% of their weekly benefit amount before it starts to affect how much they're able to get from unemployment. So you're able to earn up to 30% of your weekly benefit amount, and then every dollar above that that you earn is subtracted from your weekly benefit amount dollar for dollar. So that's how we currently limit how much someone can earn while collecting unemployment. States do that differently. New Hampshire has that 30% rule. Other surrounding states, I know Maine sets it at a fixed dollar amount, so you're able to earn $100, and then anything above that gets deducted from your weekly benefit amount. Looking at just the national picture on number of weeks available and how New Hampshire compares, there are currently 34 states that provide at least a maximum of 26 weeks, like New Hampshire, but it's only 10 of those states that have a uniform duration, like New Hampshire. So you come in, you qualify, you qualify for a weekly benefit amount as determined by the table that's in our statute, and then you're able to collect that amount multiplied by 26, so up to 26 weeks of benefits. And 10 states have that as a uniform duration. The other states have variable duration ranges, and they're dependent upon a host of factors, including how much someone earned in wages during their base period being the 4 quarters prior to your separation and filing for unemployment, from which we calculate your weekly benefit amount from. There are 37 states that actually have a variable duration, and that 37 is more than what I just said before is 34, because the 34 represented how many had a max duration of 26. There are other max durations for a number of weeks you can collect, but there are 37 states that have a duration that is variable, dependent upon those factors. The most common variable that they use, again, is the amount that you earned during your base period, during that 4-quarter period. How it is commonly used in terms of looking at your base period earnings to determine how many weeks of unemployment you get, it is commonly used to control duration, so that if your earnings were over, say, all 4 quarters of your base period, you were going to qualify for a longer duration of benefits. If your earnings were concentrated, say, within a single quarter of your base period, now your duration of benefits is going to be shorter. So that's commonly how they utilize base period earnings to determine your duration of unemployment. There are 4 states that have a variable duration that's based on a blend of factors that includes base period earnings and unemployment rate. Like proposed here, this would be tied exclusively to the unemployment rate. Florida being one of them, Georgia, Idaho, and Kansas all have variable duration that is tied to both the unemployment rate and the amount that you earned in your base period. It's important to to remember, as Chairman Infantine had brought up, the amount that an individual is eligible for in terms of their weekly benefit amount in New Hampshire compared to our surrounding states and in the country as a whole tends to be low. Right now, an individual coming in, qualifying for unemployment, the maximum weekly benefit amount that they could be eligible for is $427. That has been the case since 2007, when the legislature had added some additional tiers of benefits to the statutory table. So someone needs to earn $41,500 in their base period in order to qualify for that $427 a week. That is, so if you're earning $41,500, that's about a 54% wage replacement rate. If you are earning at our current private sector average weekly wage, that's about a 31% wage replacement rate for those individuals. And I point that out just as a lead into talking about duration here in New Hampshire. That has tended to be the biggest control on duration of unemployment in New Hampshire, has been the amount of our weekly benefit amount and the less of a wage replacement rate or a lower percentage that it is currently, with that wage replacement rate being about 31% of the average private sector wage. So prior to the pandemic, we had an average duration of 12 weeks, so 26 weeks available, 12 weeks was your average duration, and we had about 16%, so 16% of people that exhausted their benefits or used all 26 weeks. We have a current average duration of just under 17 weeks, 16.8 weeks right now on the most recent numbers, with an exhaustion rate of 13%. Nationally, the exhaustion rate was currently over 29%, and our surrounding states have exhaustion rates that are higher than New Hampshire is currently. We currently have the 7th lowest exhaustion rate in the country. So exhaustion, again, being how many people that qualify on an initial claim, how many of them use all of the weeks that are available to them. Looking at overall tax burden, as you know, we spoke and talked last week extensively about this, but our unemployment program is supported entirely by New Hampshire business. And I see some nodding heads in here, particularly Representative Avalani. He knows it very well. With prior work on trust fund solvency. Prior to the pandemic, looking at overall UI tax burden, New Hampshire had the 2nd lowest UI tax burden in the country, and that was at 0.14% of total wages paid, and it was 0.56% of taxable wages, because remember, an employer pays on the first $14,000 of annual wages to each employee, not total wages to each employee. To compare to Florida, prior to the pandemic, Florida had the lowest UI tax burden for total, compared to total wages paid at 0.12%. New Hampshire was at 0.14%. But the comparison of UI tax burden when we look just at taxable wages, New Hampshire was at 0.56, Florida was at 0.66. So very close to each other. I guess what to remember there is that New Hampshire has historically had a very low UI tax burden, and one of the lowest in the country. That tax burden has increased as a result of the pandemic. And you have, there's some information in the materials that I provided showing how many people have collected over the last 2 years. Roughly, we about one quarter, 23% of New Hampshire's total labor force relied upon the unemployment program during 20 and 21. It's about 10% more, so about 13% relied upon the unemployment program in the Great Recession, and we had about 25% relied upon it during our pandemic period. So we have seen an increase in that overall UI tax burden, but what you'll see in those materials is that the average tax rates are falling incredibly fast, and there's it's not a coincidence. It's very intentional, but they're falling at a high rate despite having paid more people in the prior 2 years than we did in the prior 15. You know, more dollars went out in 2 years than went out in the prior 15. Supported a quarter of the New Hampshire labor force. But when you look at average tax rates during the height of the pandemic, and it's the final slide in the prettier handout that I provided, but that final slide, you'll see that our peak tax rate during the pandemic compared to the Great Recession, we were about close to 40% lower. 40% lower during the pandemic, despite those crazy numbers of how much got paid out and how many people collected. And we're about 30% down from where we were at our peak. So it's falling very quickly, but again, it's not a coincidence, that's intentional. You folks approved changes as part of the budget trailer bill that eliminated surcharges. So we previously had as one of our solvency controls on our trust fund that when the fund fell, there were 2 0.5% surcharges that were added to an employer's tax rate. Both of those have been eliminated as part of the most recent budget. And in exchange for that, the triggers or the balance thresholds in the trust fund at which employers get reductions to their rate were adjusted. Right now, an employer gets a 0.5% reduction to their rate when the fund equals or exceeds $250 million over the course of a quarter. New employers start at 2.7%, so a 0.5 reduction is significant. Employers then get a 1-point reduction when the fund equals or exceeds $350 million, and they get a full 1.5% reduction, max reduction, when the fund equals or exceeds $400 million. That $250 million level was not touched as part of what was changed in the budget. The second and third levels were. They were adjusted up, and that was the give and take of getting rid of the surcharges in exchange for allowing the fund to grow to a more realistic solvent amount during a time when employers would be better able to afford supporting the fund rather than hitting them with surcharges during times when they can least afford it. We paid out $350 million in UI payments, regular state UI, during the pandemic. There was a discussion earlier about eligibility for self-employed individuals. Self-employed individuals were never paid benefits out of the state trust fund. Self-employed individuals were paid out of one of the federal CARES Act programs. So self-employed did not impact the New Hampshire Trust Fund from that perspective. Our current balance, we are at $195 million. We never borrowed during the pandemic. New Hampshire did borrow during the Great Recession. We did not borrow during the pandemic. According to our current forecast right now, we are forecast to end this year at $285 million, and we'll end 2023 at $319 million, and then 2024, for what it's worth, looking that far ahead, we forecast to end at $354 million. And we are forecasting that first 0.5% reduction to employer tax rates will kick in the first quarter of 2023, typically your most expensive quarter. So that's very timely for employers, but that's what we're currently forecasting with regard to when those fund balance reductions come back in. So I was a little bit all over the place with a lot of information there. I apologize for that. This bill does touch upon a lot of areas with solvency, with duration, but I wanted to make sure that the committee had that information and certainly can answer questions now, and I'll be here throughout the duration of today's hearing. So as other questions come up, I'll be more than happy to try to answer those as well.
Alrighty then. Any questions? Representative Avalani and then Representative Cahill. Representative Cahill, your fellow representative will yield his time. Representative Cahill, followed by Avalani. Representative Cahill, you're up.
Thank you, Mr. Chair, and thank you, Mr. Lavers. So, is it fair to understand, my understanding of what you're telling us, that the New Hampshire unemployment system is working well and serving the needs of both employers and employees when circumstances change, which may happen more than once a year, that something could happen that would make as you cited in the example, the COVID thing, we would have 12 weeks under this legislation, which obviously would not be enough. Are we doing okay as it is?
Well, I have, if the question is whether or not the unemployment program is currently performing well, I have somewhat of a vested interest in that as I sit, second in charge to Commissioner Kapatis over that program. Yes, I do believe the unemployment program is performing well and has served the state of New Hampshire well over the course of the pandemic.
Follow-up?
Follow-up.
Then you're familiar with the phrase, if it ain't broke, don't fix it?
Yes, very familiar with that.
Thank you.
Representative Avalani.
Thank you, Mr. Chairman. Thank you, Deputy Commissioner. I have a couple questions. Could you tell us the difference between the total unemployment rate and the insured unemployment rate?
Yes, so, and you'll see that was an issue or not an issue, but a clarification that the letter, the email back from U.S. Department of Labor had pointed out. So your total unemployment rate is the unemployment rate measured for your entire labor force. That is the number that people are more familiar with. Those folks here that are familiar with the insured unemployment rate, I pity you. That's a terrible thing that you're spending your time in that far and deep into the weeds like myself. But the total unemployment rate is the number of unemployed as a percentage of the total labor force. And that is based on that point-in-time survey conducted each month where they ask those households questions as to whether you are working, and if not, when did you last actively search for work, and that determines whether you are employed, unemployed, or not in the labor force. Total unemployment rate is the number that are indicated as unemployed as part of that survey. The insured unemployment rate is calculated weekly, and we look at the number of people that are filing for unemployment as a percentage of the total number of workers that are covered by unemployment insurance taxes. So we're dealing with different numerator and denominators there, and kind of coming at that issue a little bit differently. And that was, again, something that U.S. Department of Labor had pointed to in the response that they provided.
Follow-up.
Thank you again, Mr. Chairman. Thank you again, Deputy Lavers, for the follow-up. Would the IUR be a better follower in case we need to pivot quickly like we had to do during the pandemic, where we had an automatic shut-off of workers on unemployment within a matter of 24, 48, 72 hours? Within a week, you guys were inundated. I know some of those people would need more than 12 weeks, but the snapshot would be from the previous, quarters. Would that allow you to move that number quicker so you can extend it out past the 12 weeks to more needed length of time? Because I know a lot of us were shut down at least 12 weeks.
You know, it's an excellent question. So the states that do have variable duration, they tend to utilize the total unemployment rate as their control or their index, along with the base period earnings from an individual. However, the extended benefit program, one of the programs that kind of got overshadowed during the pandemic but kicked in and was available to individuals, this is the long-standing federal-state partnership program that individuals can get an additional amount of time collecting unemployment beyond the state-made available weeks. Typically, this is a 50-50 shared program. State pays half, federal government pays half. Great Recession, when it kicked in, federal government picked up the whole bill. During the pandemic, when it kicked in, the federal government picked up the whole bill. The extended benefit program that adds weeks on, that utilizes the insured unemployment rate. It looks at your average over the prior 13 weeks. And if that is, and I'd have to go back and look at this, but if that gets to a certain threshold, then you would have an additional 13 weeks of unemployment available in your state. It also looks at whether or not that average over the prior 13 was at least 120% of your IUR over a certain defined prior period. So it's not as cut and dry as just looking at those 13 weeks. But then it also does, if you get to high unemployment and your IUR over that period exceeds 6%, I believe, you then qualify for an additional 20 weeks. So states have variable duration using total unemployment rate. The extended benefit program uses the IUR, the insured unemployment rate. We do also have to remember that the total unemployment rate, the numbers that we've been releasing, folks that have been looking at the actual labor force numbers, you've probably been scratching your head as to wondering why is this number so significantly lower, specifically the number of people working. Why is this so far below where we were prior to the pandemic? Those individuals that are out of the labor force aren't picked up by the total unemployment rate. New Hampshire, as the region and the country right now, are dealing with labor force participation rates that are lower. We're looking at probably about when after the benchmarking process that I described earlier, after that is completed for the 2021 rates, New Hampshire's labor force will be off probably by about 2% from where we were prior to the pandemic. And so you're talking 15 to 20,000 individuals, a significant number for a state of this size. So those individuals are not in the labor force right now, actively trying to get them back in, but they don't get picked up by the total unemployment rate.
Yes, go on.
Thank you, Mr. Chairman. Thank you again, Deputy Commissioner. So from my math, we have 12 weeks of state unemployment. We have 13 weeks of a 50-50, and then another 20 weeks based upon IUR with another 50-50 with the federal government.
Just to clarify, with the 13 and the 20 on the extended benefits, it's a total of 20. So 13 to start, and then if you get to high unemployment, they add 7 to that, not an additional 20. Sorry, I realize I didn't clarify that earlier.
Thank you. So so basically you had, I'm sorry, Mr. Chairman?
Go ahead.
You could have 32 weeks of unemployment with the federal government picking up some and the state picking up some in the overall picture.
With the extended benefit program, yes. And there's also, just to make sure, my testimony is comprehensive and balanced. During the pandemic, as occurred during the Great Recession, the federal government kicked in with federally financed programs. What happened in the pandemic, was not only did the federal government come in and provide additional benefits for everyone, that was the $600 a week that got turned into the $300 a week that got added on to your weekly benefit amount, but they came in with the PUA program, the Pandemic Unemployment Assistance Program, and people that did not qualify for regular traditional unemployment because of a pandemic-related reason, they moved on. They were on that PUA program paid for by the feds. And if you exhausted your state UI, you moved on to a federally financed extension program, PEUC, in our laundry list of alphabet soup programs from the pandemic, but you moved on to PEUC and continued to receive benefits after exhausting state UI, financed 100% by the federal government. Now, the downside to that is you're depending on the federal government. So there is somewhat of a risk in basing the number of weeks available, basing that on a dependency or reliance upon the federal government coming through with a program that's going to provide benefits once your state program terminates. But that's what the federal government did during the pandemic. That's what they did during the Great Recession as well.
I'm going to take one, I'd like to take one last question. This is, we have other people that need to spoke to. There's a lot of different questions. I'm not sure, so I'm going to just, please be brief. We can always talk to the commissioner after, deputy commissioner afterwards. So be brief so we can get the other speakers, and then we can go back to deputy commissioner if we want, because we do have other hearings to go to. Representative Manaville, you're all set. Representative Sullivan?
Thank you. You went into detail about the extended benefits that kick in after the 26 weeks. How would those extended benefits work under this bill, which obviously has far fewer weeks?
So the way that the extended benefit program works is, and I'll make sure to provide the statutory site to members so they can review that as well. But the extended benefit program kicks in when the state's insured unemployment rate averaged over that 13-week period equals or exceeds, I believe it's set the first level at 3.5%. Our insured unemployment rate right now is 0.5%. Because again, remember, we're only measuring the number of people filing each week as a component of total number of workers covered by unemployment insurance. With the 3.5% average IUR, that would kick in the first level of 13 weeks. And if your IUR was averaged, I believe it's at 6%, but again, I need to look at the statute. All right here, if I had it all memorized, then I could go right to the page, but I'm not that good. But once you get to that 6% average IUR over those 13 weeks, then 20 weeks would be available. And again, it's that shared financing, so half would come out of the unemployment trust fund, our state trust fund, and half would come from the federal government.
I understand the 13 and the 20. What I'm not sure of is whether those would kick in after, let's say, I think at one point you said the calculated rate according to these percentages would be 12 weeks. So basically you would have 13 and 20 on top of 12?
Correct. It would be, you would, in terms of the program hierarchy, you would move on to extended benefits after exhausting your state UI benefits.
Representative Cahill.
Thank you for your indulgence, Mr. Chairman, and thank you, Deputy Secretary Lavers. So, regardless of how many weeks there are, with our $427 maximum, it's true that no one's getting that comfortable in staying out of work. I mean, you tell us that the average is 12 weeks or 15 weeks. That's not a long time to be out of work because you're not making enough to make your bills with our unemployment payment, correct?
In the current average weekly benefit amount in New Hampshire, I did tell you earlier the average, or the maximum amount available is $427. The average weekly benefit amount right now in New Hampshire is $303. That just goes to show you that there's a lot of folks from lower paying sectors that are collecting. So think of hospitality, think of retail. Those folks tend to have lower average weekly wages, hence a lower average weekly benefit amount right now at $303. So even at, as I'd indicated before, the 427, which is our maximum weekly benefit amount available in the state, that's about a 31% wage replacement rate for individuals earning at the state private sector average weekly wage.
Thank you.
Thank you very much, Chairman Infantine, House Labor Committee. It's a pleasure to be before you. For the record, my name's Gary Abbott. I'm the Executive Vice President.
Can't hear you, Gary.
I'm the Executive Vice President of the Associated General Contractors of New Hampshire, and I'm here today completely understanding the concept of the bill before you. But I think it has some unintended consequences, and it came to light when we reviewed the bill with the construction industry of who I represent. We have seasonal workers in some of our industries within construction. We can't work during the winter because of the colder temperatures. It's no fault of the employee, it's no fault of the company, but many of those individuals go on unemployment. They still are required to look for work, do all of those things, but the time frame of cutting this to 12 weeks, we know the winter is somewhere between 16 and 20 weeks for seasonal employment when it comes to for our construction workers in New Hampshire. We see this cut as maybe it's problematic for the industry in the sense of encouraging people to come to our industry and work for, say, highway work and paving, that they know they're going to end up being laid off. They know that if you reduce it, they won't get even the small amount that we were talking about in the benefit that to help hold them over to it. But I think it's there's no doubt my years of working with the unemployment department, the different tables, the different benefits, the way it works and calculated, it's not an easy system in the sense to completely comprehend, but we do. Businesses, the state, I can tell you in 2008, a lot of people come together because when we had the last crisis, trying to figure out how to make sure the system stays alive. So I've been there when some of these other disasters, COVID was not something we were gathered by businesses because the federal government came in and stepped in and helped. But based on how this reads at the moment, we don't support it. We oppose the legislation, but it's really because of the seasonal piece. There may be ways to address it, and we'd be glad to work with the sponsor and legislators if there is a way to work with that. But I think we understand how it would benefit businesses by if you paid less and less weeks, the whole thing, the system mathematically. But we understand the concept, but we're concerned about this change. And with that, I would end my testimony, and thank you very much for the opportunity.
Thank you. Any questions for Mr. Abbott? Mr. Manaville? Representative Manaville, I'm sorry. Representative Avaloni.
Thank you, Mr. Chairman. Thank you, Mr. Abbott. What number instead of the 12 would you be looking for to see?
Well, I think the commissioner stated like what the average is, and that's about where seasonal employment would be at. So I'd be looking at that, and the department would have the better numbers to really try to address this. What would be the right number to start at, and what would be the right number to if you did this formula? I get your question. I don't have an exact answer. I'd rather have the department look at seasonal employers. Construction is not the only seasonal employer in the state. There are many others, and I'd want all of those in that mix with that discussion. That's really the fair answer.
He wants a real number. Just having some fun, guys. Representative Seaworth.
Thank you, Mr. Chairman, and thank you for your testimony. One thing I'd kind of like you to clarify for us, I know some people hear that you have employers with seasonal workers and they want them to go on unemployment. And people imagine they're trying to save some money by asking someone else to pay, but that's not how the system works, as I understand.
It's not completely how the system works.
Yeah.
Trust me, if you're a negative balance employer, you pay a much higher rate with a different table. That's why I say the system's not the same for each employer. And that's where the commissioner talks about people paid. But what you don't see is things like us talking to DOT of whether any of our people could be a snowplower driver or some other. We're always looking for those opportunities. But when there isn't, when there just plainly isn't, this is at least a safety net. And we understand that as businesses putting and contributing money into that system. So I think you're right. I really appreciate the question because it's not the same for every employer and it's not the same for every seasonal employer.
Mr. Abbott, for our new members here, would you just give me a 3 or 4 second tutorial to the people about what a negative employer is? Because I don't think some of these people know.
Those are ones in which their payments, the benefits to employees had exceeded, so they jumped to another chart to pay more than other employers. I hope that explains it, because
But basically, they're taking out more than they put in, so they get into a different chart, and they have to pay more than they average.
yeah, it's kind of you don't want to be in the negative chart if you can, and I think every employer would like to not be in it.
Any other questions for Mr. Abbott? Seeing none, thank you very much.
Thank you.
I apologize in advance for not pronouncing this person's name right. Nicholas Adolphson? Nick, sorry.
Adolphson. You just about had it.
Adolphson. Okay. Thank you.
Good afternoon, Chairman Infantine, members of the committee. I am Nick Adolphson. I am from the state north of you, in the state of Maine. I live in the town of Rockport, Maine. I'm here today representing the Opportunity Solutions Project. I just want to thank you for giving me a couple of minutes. These guys covered much of what I wanted to cover, and Mr. Lavers probably has forgotten more today about unemployment than will probably know in my lifetime. So you don't need me to sit here and wax eloquent on the program, but this is an issue that, as an organization, we work with states around the country on, and we're working on there's a number of bills, and we work closely with unemployment agencies and legislators in North Carolina, Florida, most recently Tennessee, the state of Iowa, on this issue specifically. And for us, it's all about getting people back to work and get people back to work as quickly as possible. And so what I want to do is I want to just encourage you. So New Hampshire is a fantastic state. It's a great state. And I'm a guy from Maine, proud of being from Maine. And so it ought to mean a lot hearing it come from somebody who would like to be a competitor with New Hampshire, though I don't think we're quite there. But it's great for a lot of reasons. One of the big reasons is that New Hampshire is one of the preeminent places that says to businesses and workers, we want you here. I can tell you that New Hampshire serves as a reminder to the rest of New England and the entire Northeast that you don't need to be in the Sun Belt with warm winters and booming metro areas like Orlando and Nashville to be a leading pro-business state. You just need to continue growing in the principles you have that you've governed by over the past decades. That's why, honestly, and you know this, your competition isn't Maine or Vermont. It's not even Massachusetts or Connecticut. It's the no-income tax, business-friendly states like Florida, like Tennessee, like Iowa around the country. This bill, HB 1337, is a statement that you want to be more than just the pro-business state of New England or the Northeast, but that you want to continue to lead nationally on economic issues. States like Florida and Tennessee already do what this bill does, and they've grown from it. Florida in particular, Tennessee just passed it. And so I'm not going to hash back through exactly how it works. I'm not going to hash back through the benefits. I think you've heard those today already. But I just want to encourage you. North Carolina passed this. And I had the opportunity to sit for a long time with the representative in her office and talk about why she worked toward this, and it was post-Great Recession, and they had a disaster on their hands. So they had to fix it. New Hampshire doesn't have a disaster on its hands. You guys have done a good job. Tennessee passed it last year, not because they had a disaster on their hands, but because they want to be the best. They want to keep drawing businesses to their state. And I would encourage you, as the leaders of the state of New Hampshire, to follow that path. And I am happy to take any questions you have.
Seeing none, thank you very much for your testimony. Appreciate it. Mike Summers, New Hampshire Lodging and Restaurant Association.
Good afternoon, Mr. Chairman, members of the committee. For the record, my name is Mike Summers, President and CEO of the New Hampshire Lodging and Restaurant Association. I'll be very brief. I am no expert in the details, as Deputy Commissioner Lavers has given you way more content that I didn't even absorb it all. But that said, in discussing this bill with my board leadership, they asked me to be here today and really just weigh in support of this as a concept. Obviously, there are way more minutia and details that need to be worked out, but they did ask me to be here to speak to this. They feel that it's kind of a common sense approach. It's a very New Hampshire kind of a unique sort of approach. The one thing that I will add in listening to Deputy Commissioner Lavers is I think he alluded to the fact that maybe there is a way to, or maybe there should be a way to build in some sort of a shut-off switch in the event that we have another pandemic. As you know, the hospitality industry, we just got crushed by this thing. I mean, we were shut down, open one day, shut down the next. So maybe there is a way that within the system we could build some sort of a safety valve in there. So that's the only comment that I would make. Beyond that, I'm happy to answer questions, and thank you for your time. Thank you much.
Thank you. Seeing none, thank you very much. Roy Schweiker. Welcome.
Thank you, Mr. Chairman and members of the committee. I'm Roy Schweiker from Concord. I retired from the state like 9 years ago, and since then I've been volunteering with a group that helps people find jobs. You may have seen our notices in the Concord Monitor or the Insider. Anyway, part of the problem with this is there's a structural imbalance. There are some, jobs that there's a shortage of people, so, it seems like people aren't looking for work, but that's because people aren't qualified for them. Then there's jobs that there's a surplus of people in, so those people may stay unemployed longer. And the particular thing we found is a lot of our people are in their 50s and over. There's serious discrimination against older people. Companies just don't want them. I mean, I know a woman who used to be a legal secretary. She can't find that job anymore, but she can't even get a job as a restaurant hostess because they want someone young and perky. And another example of this is I used to go on plant tours before the pandemic, and there was a high-tech firm that said, we have 7 jobs we can't fill. And I said, well, that's funny. I looked at your website this morning, and there's only 1 job posted on it. How seriously are you trying to fill those 7 jobs? So I think that, this company saying they need workers is maybe a little bit exaggerated. I mean, once again, I know a guy who can't get a job at Dunkin' Donuts. And so they say, well, we need people. Well, people show up, but if they're over 50, they won't hire them. So, and this is getting into something I want to talk about, and that is that, as the gentleman with the seasonal work says, there's different, difficulties with people getting work. And if the purpose of this bill is to cut the state's budget, well, sure. You start off by saying we'll only, give the average number of weeks people get. Well, that saves you half your money right away. 2 more years, you do it again. You say, well, 12 weeks is too long because the average is only 8 now, so we'll cut it back to 8 and then do it to 6 and 4. And pretty soon the companies don't pay anything at all if you want to just keep cutting it back. But if you say, part of the purpose of this is to help people who are unemployed and need help, then that's kind of a mistake. I think some people may be feeling that there are people who abuse the unemployment system. I'm sure that's true. I'm not going to deny it at all. But there are people that really need help. And that's kind of another issue I have that I wanted to come here today. I looked on the website for New Hampshire Works. That's the job seekers interface to the employment security. And I discovered that their New Hampshire Works offices are open 8 to 4:30, Monday to Friday. Except when I went to the office, I discovered there was a sign on the door, it's only open 12 to 4, and you can only stay there for half an hour. So, you know, if there are these unemployed people that are trying to get help finding a job, you know, why are we cutting back the employment assistance part of the department by over 50%? Now they don't have the real job fairs people can go to. They have the virtual job fairs. Those are usually 11 to 1. So if the office doesn't even open till noon, you already missed half the virtual job fair if you show up at the New Hampshire Works to get a job. So, you know, what I think you really need to do, if you're afraid of these malingering types or whatever, is say, okay, you know, we'll be kind of generous. We'll give everybody, you know, 6 weeks, 8 weeks, whatever. You know, you fill out the forms and that's okay. But then once you start running over that, let's give you some real help. And now maybe if they're in a seasonal industry, that real help is going to be less, you know, well, your employer is willing to pay a high unemployment rate, so we're not going to really make you find something because they're willing to pay for this. But maybe, you know, this person needs advice on getting a job. Maybe you need to start comparing them with the jobs they're applying for, as in if a restaurant that keeps claiming they're not getting any workers is turning these people down, you need to go back to the employer and say, look what's going on here. So I think we need to reopen the New Hampshire Works part of the unemployment system, and I'm sure the Deputy Commissioner can give you some advice on that, why it is when employers are short of help that we're not having the offices open so people can apply. I mean, half an hour, I don't know how much time most of you people spend on the internet, but you know, just checking your email for job leads or going to a job site, you probably can't do that in half an hour. And then let's say you have to fill out an application. All the applications are online now, and they tend to take an hour to fill out. How do you fill out an hour application in half an hour? And remember, you've already used up your time just checking the email to find it. So I think I'll be happy to hang around and hear just what the Deputy Commissioner has to say about why we're not doing more to help people get jobs. That's the way I see to cut the, you know, expensive unemployment compensation, is not simply to say, well, these people are malingerers, let's pay fewer weeks. Let's help these people find jobs, and then you won't have to pay. Thank you.
Any questions for the speaker? Mr. Representative Cahill, I know you're itching to ask a question.
Thank you very much, Mr. Chairman, and thank you, sir, for taking my question. I wanted to thank you, actually, because earlier today I brought up the question about whether or not it was different in, you know, the unemployment rate was different in Coos than it is in Rockingham, and I really neglected to think about the age and the skill set of the people who were out of work. So I really appreciate your coming in and telling us about that. It's an important thing. I do want to defend the Deputy Commissioner. I think they may be having trouble staffing like so many other people are, but I'm sure he'd be willing to take your input. So it was really more of a comment and a thank you than a question. But again, thank you very much.
May I respond to that?
Would you believe? Yes, you may.
Yeah, would you believe? Yeah.
Okay, I mean, first off, it just depends on how things are. We used to have people who were engineers show up because New Hampshire, after the Great Recession, was much slower to do construction projects. So one of our gentlemen actually had to go down and work in Massachusetts because they had much more engineering work. But he lives in New Hampshire and commutes down there every day, and that's, you know, kind of a waste of a resource. But now, you know, New Hampshire's kind of caught up on that. And, you know, the other thing is I would be happy to hear that the Deputy Commissioner tell us that, yes, we have a problem with resources, but isn't that your job? If the reason people aren't being able to find work is the department doesn't have enough resources, then you've got to increase their budget or whatever it takes to do that? Thank you.
Any further questions? Seeing none, thank you very much. Mr. Berkey, welcome.
Thank you, Mr. Chairman and members of the committee. For your record, Bruce Berkey with Sheen Finney Capital Group, and here today representing the National Federation of Independent Business. Over 1,400 small business owners here in the state of New Hampshire are members. And just 2 points. One is that, like the New Hampshire Lodging and Restaurant Association, we do support this bill in concept. Perhaps it needs some work with respect to a safety net, or how it fits in with the federal, how it's complemented by the federal support. But we have seen this work in other states. I know Florida and Georgia and Tennessee have been mentioned, and my counterparts with NFIB down there have said this is a good approach to the issue. So we support the measure. The second point I'd like to make, and it's not necessarily related to this bill directly, but it is related to Deputy Commissioner Lavers' comments. And I don't think he would take issue with what he said, but I will take issue with what he said when he said that he would like to try and forget about the experience that he and his staff had in the spring of 2020. I think we should all remember the experience that he had and his staff had in 2020 because they performed outstanding service to the state of New Hampshire. And it was just, I first worked for this New Hampshire House in 1982. So I've been around here for 40 years. I've never seen a state agency respond in the way that they did to serve the state, to serve the people of the state in such a short time frame and in such an emergency type situation. So I just want to publicly applaud his department with the leadership of Commissioner Kapatis and Deputy Commissioner Lavers and the whole team over there. Thank you, Mr. Chairman.
Thank you, and thank you for your kind words. Representative Cahill.
Thank you, Mr. Chairman, and thank you, Mr. Berkey. And thank you for saying that what you just stated about the department. I had many, many constituents reach out to me, and Mr. Lavers was very responsive, and they have done admirable work. My question...
I would believe that.
Yeah. Yes. My question is, do we have a problem, like they said they had in Florida and these other states, do we have that problem here in New Hampshire with people really laying around and collecting lavish unemployment benefits and being discouraged from working?
I think, I don't have any specific examples for you today, Representative Cahill, but I heard some experiences from small business and medium-sized businesses throughout the state of New Hampshire during the process. So my answer would be yes, I think we did have that problem for a while.
Were you referring to the period when the federal government was sending out an extra $600 and allowing other people in sort of normally uncovered employers to collect benefits? Was it the COVID period you're referring to, or pre-COVID?
It was the COVID period.
Thank you.
Any other questions for Mr. Berkey? Seeing none, are there any additional questions of Deputy Commissioner Lavers? All right, is there anyone else who would like to speak on this bill? Is that card for this bill? Don McKinney, you're recognized to speak.
Good afternoon. I apologize for the late card. I wasn't planning on speaking, but I just feel like there are a couple of things. I'm Don McKinney. I work for New Hampshire Legal Assistance, and I feel we have a project where we've been assisting folks with unemployment, access to unemployment benefits. We've had the project for a long time. It's been incredibly busy over the last 2 years trying to assist folks in accessing benefits, and I would echo everyone's comments about the work that the department has done. And I was just jotting down notes, and now I can't find them.
All right.
Sorry.
Take your time.
I guess I think what it comes down to is that I just wanted to kind of highlight a couple of things I've heard that I think sum up what our position is on the bill, which is we feel like it's unnecessary. It really is a solution in search of a problem. As you've heard from the data that the Deputy Commissioner shared, unemployment is low in our state. The duration of people on unemployment is low in our state. The benefit of amount for folks on unemployment is low. The folks that, and then this is getting to the kind of last points that folks were making, the folks that are still on unemployment after 12 weeks tend to fall into two categories. Those that are older adults who are having difficulty finding work that they're skilled for in some cases, and then also those that have limited availability based, and that generally falls into categories of people with limited access to childcare, which I think everyone has probably heard about during this pandemic. It's really incredibly difficult to access a reliable childcare, and with even if you have reliable childcare, there are difficulties in terms of throughout the pandemic, folks having to isolate when there's exposures at the childcare facilities, etc. So it's the folks that we're talking about that are on for more than 12 weeks, I think have specific challenges and barriers that I wouldn't characterize anyone who's on unemployment for more than 12 weeks as someone who is in any way taking advantage of that. And I think that I can speak to that specifically because for two reasons. One, people are trying to make ends meet when they're on unemployment. They're in a difficult situation where they've lost their job and they're trying to continue to pay their bills, feed their families, pay for childcare, keep their car in good repair so they can get to interviews, etc., and get to work, etc. And the fact of the matter is they can't afford to be unemployed, as we heard. They can't pay their bills on unemployment. And they can't afford to be, even more so than not being unemployed, they can't afford to be without unemployment. On the chance that someone is 13, 14, 15 weeks on unemployment, which this bill would ramp back, the folks that are on unemployment, those extra weeks, you're potentially, by ending that, looking at the ripple effect of that in terms of people becoming potentially homeless because they're unable to pay their rent or their mortgage or etc. So it can compound the problem, and we all know we have a housing problem in our state. So I guess I would just say that we think this is just a bill that's a solution in search of a problem, and would strongly urge the committee not to support it. Thank you.
Thank you. Any questions? Seeing none, thank you very much. Is there anyone left here in the room that would like to speak on this bill, 1337? Seeing none, I'm going to close the hearing. We're going to try to get caught up in the next two bills, lightning round, and I'm going to hand it over to Brian for a moment.
Thank you, Mr. Chairman. So next up, we have the House Bill 1415. I do not have a pink card from any of the sponsors. I see that I now do. So Representative Lanzera, prime sponsor of this bill, if you could introduce your bill, please.
Hello. Excuse me. Thank you, Mr. Chairman and members of the committee. I'm Representative Tom Lanzera from Nashua. I come before you today to introduce House Bill 1415, an act relative to employer health screening reimbursement. What this bill seeks to accomplish is to amend RSA 25757 to include reimbursement of pre-employment expenses and employee expenses. As the statute stands currently, it relates only to an already employed employee of an employer. HB 1415 only to an already employee, will then allow a potential candidate for employment to seek reimbursement for expenses incurred as a condition of full employment. While many employers contract with health systems, laboratory centers for their pre-employment needs, the current RSA does not take into account the cost of the employer's candidate for the total encompassed cost of pre-employment, such as mileage, tolls, and transportation. Thank you for your time.
Thank you. Any Any questions? Representative Valvolani.
Thank you, Mr. Chairman, and thank you, Representative Lanzara. Could you specify, it says that is this for employees or is this for pre-employment screenings? Because you said it two different ways.
It would include the candidates that are chosen by the employer and in continuing for the employees.
Thank you.
Thank you.
If I may clarify on that question, I'm looking at the text of the bill. I see references to employee, I see references to employer. Could you help us with the line that covers the pre-employment condition?
I think you'll have to follow up with that.
All right, thank you. Further questions for the representative? Seeing none, thank you very much.
Thank you again.
Next up, I would like to ask Lexi Rojas, representing the Hampshire Department of Labor, and no position on the bill.
Thank you. I'm Lexi Ross. I'm an attorney with the New Hampshire Department of Labor, and we understand what the intent of the bill is. We have no position. We are confused by it. So RSA 275.3 does state it shall be unlawful for any employer, as defined by RSA 275.4, to require an employee or applicant for employment to pay the cost of medical examination or the cost of furnishing any records required by the employer as a condition of employment.
Could you get a little closer to the microphone?
Sorry.
We're having some trouble in the corner.
Yes. So there's RSA 275.3 does already protect applicants as a condition of employment from having to incur costs. There's also RSA 275.57, which is, I understand what they're trying to amend, but it already broadly addresses this issue. Although not specific to applicants, we do have RSA 275.3. There's a lab rule 80302 subsection B that also specifies, adds a specificity, additional detail with respect to these types of laws. And 275.48 makes it illegal for an employer to mandate an employee to incur a cost to the benefit of the employer. So there are statutes already in place to protect employees in these situations. That is how the Department of Labor interprets the law currently, is to protect employees in this situation and potential employees, the applicants. We do get a number of calls. We were flooded with calls during the pandemic with questions about whether or not the law mandates employees to protects employees from incurring costs for testing, especially COVID testing. And that was our interpretation at the time as well. I believe the special circumstances of the pandemic led to employers becoming confused, but our laws did address it already. So we are confused that we believe that this bill to be duplicative of the statutes that are already in place. Any questions?
Thank you for the testimony. Questions, I'll start with Representative Prout.
Thank you. Do you see anything new in this bill, specifically regarding the payment for travel expenses or to the medical examination or the test or anything else? Is that already covered, or would that be new?
It's already covered where mileage is to be reimbursed. So the employer can, so for instance, if I were an employee, I can't say I want to get my test in Florida so I can get a free trip to Disney while I'm out there. The employer can say, please get your testing at the Rite Aid down the block to help save on cost, but they are to reimburse for cost of mileage.
Thank you. Follow up. Yeah. What was the section of rule? You said the number very quickly.
Oh, my apologies. So there's lab rule 80302B, so .02B, does specifically address the mileage issue as well. I can read it too. I have that up. Every employer shall provide his or her employees, oh, sorry, that's the wrong one, 80302. Pursuant to RSA 275-48, no employer shall require an employee or applicant for employment to pay for the cost of medical examination, non-required drug or alcohol testing records required by the employer, or any item required by and for the benefit of the employer as a condition of employment. This shall not include examinations, permits, or licenses required by the state or federal law. So there are specific, so it's already protected, so we are confused.
Thank you.
Representative Babalani.
Thank you, Mr. Chairman, and thank you for taking the questions. You referenced in 80302B 275-48.
Yes, 275-48, if you look at it, it makes it illegal for an employee under I, subsection, I know it's a long statute, that one.
It is. I is the date the recovery of overpayment will begin and end.
So, sorry, 275 subsection, so it's 275:48I, and then it starts off with 1, and if you go into, I read it this morning, double check it was in there. I should have brought in a copy and highlighted it. Employer. So it's 12 for any purposes in which the employer and employee mutually agree that does not grant financial advantage to the employer. So here, if you're mandating an employee go get testing, it's to the financial benefit of the employer not to incur that cost. So they can't. So even if they both agree to it, they're not legally able to do that. The employer has to pay for the cost of travel to get that testing. So you can't force someone to get a test without having to incur the cost associated with going and getting that testing done.
Follow up.
Thank you, Mr. Chairman. So just to be clear, health screening is covered. Their time there and from is covered if it's during their work hours. Their mileage is covered unless they're using a company vehicle.
Even if it's not during their work hours, they're to be reimbursed, including mileage. So yes.
Didn't get all that. So it's if
So
I didn't hear that.
So even if it's off there, if I tell you to get a if you're not working on a Saturday, and I'm your employer, and I mandate you get a test before you return to work on Monday, only time you can get it is that weekend. I am responsible for making sure that I reimburse you and pay you for your time.
Thank you. Thank you. I didn't know that.
Other questions? Seeing none, thank you very much for your input. I have one more card. Kate Horgan, representing the New Hampshire Association of Counties, opposed to the bill.
Thank you, Mr. Chair, members of the committee. My name is Kate Horgan. I represent the New Hampshire Association of Counties, which is all of your elected and appointed officials. We are also confused by the bill, but I will point out that the current language in the bill does not include any pre-existing relationships that we may have with providers. So, for example, a COVID test at the nursing home. If we're in outbreak, we're required to test by CMS rules. So you have to have a test to come in. We're offering that test for free at the nursing home for you to come in. It's all set. There's no mileage. You're already coming to work. You're good to go. Take your test, move on. This bill would allow somebody to go somewhere else, get a test, and then require the nursing home to pay that bill for something we're already offering for free. So based on those reasons, we are opposed to the bill, and we also believe it's already covered under current statute. So I'm happy to take any questions.
All right, thank you very much. Are there questions? I do not see any questions, so thank you again.
Thank you.
I do not have any other pink cards for this bill. Is there anybody in the audience who wants to speak on this bill? I do not see anyone, so I will close the hearing on HB 415, and we are already into HB 472. So I will begin the hearing on that. Do I have a pink card from the sponsor yet? right, so to introduce House Bill 1472, I have Tony LeBranche, I believe you're the prime sponsor.
I am indeed. Thank you. And good afternoon, House Labor Committee. For the record, my name is Representative Tony LeBranche, and I represent the town of Amherst, and I come before you today to introduce House Bill 1472, which would prohibit employers from conducting certain anti-union activities. Because this bill is short, I'll just read it out to the committee. Anti-union activities prohibited. No employer shall promise, threaten, or take any action to permanently replace any employee who participates in a strike as defined by Section 501, parentheses 2 of the Labor Management Relations Act, not prohibited under state law. B, to discriminate against an employee who is working or has unconditionally offered to return to work for the employer because the employee supported or participated in such a strike. Or C, to lock out, suspend, or otherwise withhold employment from employees in order to influence the position of such employees or representative of such employees in collective bargaining prior to a strike. Section 2 of the bill. No employer shall engage in anti-union training of any kind, including requiring or coercing an employee to view a video that casts unions in a negative light. This bill would simply strengthen worker protections and creates an environment where workers truly have the freedom to choose whether they would like to unionize or not. Currently, many workplaces such as Target, Walmart, American Eagle, Home Depot, Amazon, all require new employees to watch anti-union videos in their training. This creates a bias in the workplace against unionizing. For example, let's take American Eagle where I worked. It was primarily staffed by those below the age of 24. Many of them, it was their first job. I want you to imagine this, a 16-year-old, it's their first job, they've never even heard of a union. And the first time that they ever learn about a union is through this training that paints unionization in a negative light. This bias taints any unionization effort that could come about. I personally believe the only time that there should be any campaigning, one way or another, on unionization is during a union election. This bill would simply level the playing field and remove anti-union bias from the workplace so that workers can make up their minds on unionization without an undue pressure by the employer. With that, I ask that the committee pass this bill with an ought-to-pass recommendation.
Thank you very much. Are there questions for the representative? I don't see any questions, so thank you again for your testimony. I have a card, again from the New Hampshire Department of Labor, Lexi Rojas, with no position on the bill.
Thank you. So the Department of Labor understands the bill. We take no position on it, as I stated in the card. We just wanted to make it clear that our reading of the bill is that it does not change our current penalty provisions, in that if an employer were to violate this and someone were to lose employment or not be given a position because of this bill, the employer will be given 30 days to correct, a 30-day warning. And the only recourse we'd have in addition after that, if they did not correct it, was a $2,500 fine, up to $2,500. So I just wanted to make that clear.
Thank you for your input. Are there questions for the Department of Labor? I don't see any hands, so thank you very much.
Thank you.
And those are, I believe, the only two cards I have on this bill. We're getting kind of thin in the audience. If there's anyone who wished to testify that didn't get a chance. Seeing none. These two. I will close the hearing on 1472. We have only one more bill left for the day. That is scheduled for 3:15. So we'll take a half-hour break and reconvene at that time. Thank you.
Can I have everyone's attention, please? Is this yours, Representative Sullivan? 1385? Thank you. Yours is offered instead. This one, 13. Would- You,
1385 is credit.
yeah. Okay, I got 1076. Everyone should have the following amendments: 1076, 1386. That's the heat and cold. And is that yours, Brian? That's 2022-0203H. And then we have, then you have one from Mandeville, 1207. So everyone should have those three, and then I'll hand out another one for another one that's not happening today when we're done.
The only one that was passed out was Sullivan's, and then we got an adjutant. I did not see a Mandeville.
Representative Mandeville, do you have a lot of copies? Would you please, yeah, go down to Heather, you know who our assistant Heather is? Okay. No, I got those. Representative Mandeville will give you, it's 1207. House Bill 1207.
Do you have a list of the ones we're going to exec so I can pull out the
Mm-hmm.
printed sheets?
Mm-hmm. Mm-hmm. I was trying to keep with our schedule here.
Oh, yeah, no, I know we can do that. I can do that while we're listening to Mr. LaBranch.
Have you written out the list of execs in the order we're doing them?
I'm doing them numerically.
Do you have the list of all of them, so
I will. I do. So can I give them to him first?
yes.
Okay. They're all written here. Glenn, ITL.
Oh, so they are.
I'll give you all.
So this has all.
No, I wrote it.
Oh, you wrote it. All right.
2-minute warning, folks. I lost my apple and now I'm irritated. Thought it was in my car. It's not in my car, not in my briefcase. I'm appleless. Has everybody seen the schedule for the February 10th? All should have been emailed to you. Okay. We were talking earlier, I believe, we're not gonna, we're gonna have a House session on the week of the 15th. I believe this, the state of the state or whatever by the governor, and then we'll have a House session, so I will not have any, excuse me, yeah, full House session, so it will not be a committee that week. I will. A list of all the bills we're going to exec. I might exec a few more. We'll see how many we get to today. But we'll at least get to the ones we have to and the ones we have the amendments. Okay, we're a minute late. sorry, Mom. We're going to open the hearing on House Bill 1403 and recognize Representative LaBranch.
Hello, House Labor Law Committee again today. For the record, my name's Representative Tony LaBranch, and I represent the town of Amherst. I believe at the previous public hearing on the CACR that accompanies this, there are a lot of issues that were brought up with the bill, and with that, I ask that the committee ITL this bill. Thank you.
Hold on. Sorry, just want to make sure that aren't any questions. Are there any questions for the representative? Seeing none, thank you very much. Lino, Representative Avaloni.
Thank you, Mr. Chairman. Would a motion to ITL this bill be out of order?
It's going to executive, no, it will not be out of order. But if you could hold that motion for a moment, please.
I was just asking if it would be out of order.
It would
If
not.
I'll wait.
No.
Thank you.
All right, so we are done for the session for the day. I'd like to move into some we're done with our hearings for the day. I'd like to move into executive session. There's a lot of moving parts here, and I'm going to try to do things in as best order as I can. So bear with me because I have a lot of papers here, okay? There are a list of bills that I had told you that I wanted to exec today. If we get through those, I'd like to exec a few more. So, again, give me a couple minutes here. I have misplaced a couple things here. Where the heck is my stuff? I'm going to go the two early bills first, if that is okay with everyone, and then we'll move on to some other ones. And I will try to go numerically if I can. House Bill 1207. I would recognize Representative Avalon. Nope. I'm going to recognize. No.
Mr. Chairman, I move ITL.
No.
Oh.
Representative Mandeville.
Yes, thank you, Mr. Chairman. I'd like to move for and also pass with an amendment on 1207.
Is that seconded? Seconded by DeSilvestro. You may speak to your motion. Amendment number 2022-0286H.
Thank you, Mr. Chairman. The amendment that is offered has as its objective, let's say, the greatest need of addressing the unlikely but possible circumstances where it's difficult or even impossible for an employee to get to the polls to vote on voting day. There are precedents for such a bill as amended. I haven't actually found bills that are similar to the bill originally presented, but 29 states.
May I ask you just to hold for a moment?
Sorry.
You were going to make copies of this?
It was passed around.
Okay, I apologize. They got stuck with me. So why don't you just give us a minute to hand these out, please?
Certainly. Certainly.
So everyone can take a read first.
There's some more here. Oh, do you,
You still need, Andrew, the three gentlemen in the middle?
there's more.
That's all right. All right, maybe we continue. Thank you.
Thank you. As I was saying, the need addressed here is the unlikely but possible situation where employees are unable or it's extremely difficult for them to get to the polls on Election Day. There are, as far as I could find, no other states that had a bill quite like the one originally presented, but there are 29 states that have bills very much like the one presented by this amendment, including states such as Kansas, Texas, Tennessee, Oklahoma, and particularly Utah, on which this bill is primarily based, not entirely, but it's very similar. One thing this amendment would do would be to correct an error that everyone perceived in the bill when it came up for hearing, and instead of it indicating that an employee would get at least 3 hours off, this amended version states that an employee would get up to 2 hours off. In addition, it gives the employer the right to get advance notice and select the time off, although an employee would be allowed to ask for 2 hours at the beginning or the end of the shift, or as much or as little part of that as they would need. And importantly, it excludes all employees that have 3 consecutive hours not on the job while the polls are open. Now that provides a variety of protections for employers. First of all, most employees, I'd say probably the vast majority of employees, would have 3 consecutive hours not on the job when the polls are open. So in effect, this would apply only to the employees who are most at risk of not having time to get to the polls to vote. Secondly, it would provide protection in the context, as was asked at the hearing, in relation to part-time employees, because it's almost unimaginable that a part-time employee would not have 3 consecutive hours when polls were open when they were not on the job. Thirdly, it would protect in the context, as asked about also at the hearing, of employees that might have more than one employer, because this amendment addresses a situation where an employee has 3 consecutive hours while the polls are open, not on the job. And that's important language, because if you have 2 jobs, each one is protected by that. The job is the job in question. And so no employer would be asked to bear the burden of an employee having multiple jobs that precluded him from getting to the polls. The greatest value of this amendment, as I see it, is that it allows, as I said, it allows those who would legitimately struggle to get to the polls to have a little bit of opportunity to do that. And it would also indicate the value and importance of voting in a democracy by conveying that message. And I might say to some of my friends here that it would also potentially act contrarily to the idea that we need some kind of national day off for election days by virtue of providing a sensible alternative to that to work in the circumstances where it is most needed. And so finally, I would ask if this amendment could be allowed to proceed. I think we would find ourselves with a more thoughtful approach, a more appropriate approach, and one more consistent with the majority of states in this country to allow consideration of this up to 2-hour right under certain circumstances to have time to get to the polls. Thank you, Mr. Chairman.
All right, thank you. Any comments? Anyone else like to speak? Representative Alani.
Thank you, Mr. Chairman. Just a question. For the 3 or more consecutive hours between the time polls open and close, so this would preclude people that work 9 to 5. If the polls are open 7 to 7, they would have to have an extra 2 hours off. Or am I mistaken?
Up to 2 hours.
Follow up?
Follow up.
Even though the polls are open 2 hours before and 2 hours after their jobs are.
That's the way it's written. There are some other states, since you ask, and I appreciate the question, that do address it that way, 2 hours on either side. That's an alternative to 3 consecutive. So that would be an option, but that's not what's here.
Thank you.
I have a question. So there's still, the concept here from the last sentence is it still employer pays the hours regardless?
Correct. The large majority of states that have this law or an equivalent of it have that. Not all of them, although the law review article I looked at it as suggested it was implied in all of them, but that's not necessarily the case.
Any other questions? Representative
Pimentel.
Yes, thank you. I apologize.
Thank you, Mr. Chairman.
Yeah,
just a math question. So if it's 3 consecutive hours, and in the previous situation there was 2 hours before and 2 hours after, would that mean the employer would only have to pay for 1 hour? Because that would add up to 3?
That's not the way I understand this or intended to draft it. The idea is that the employee is allowed up to 2 hours. That signifies that they would take what they needed. That might be 15 minutes. That might be an hour. That might be 2 hours. It's dependent on the situation.
Representative Prout.
Following up on that, how would what they need to be calculated? Because it says that they can be allowed to take it at the end of the workday if they're concerned about a long line and want to have the full 2 hours just in case. Would the employer be required to grant that out of the concern for the long line?
If the employee is not exempt by virtue of having had 3 other hours available, then the answer to your question is yes. Again, as this is partly a matter of employees working with employers, there are plenty of employers that do this voluntarily. Obviously, this wouldn't affect those that would want to do things voluntarily. It would only deal with the ones where there might be a problem. And the idea at the end of the day, for example, in a place, if there is any, and I'm not familiar with it, but if there were, that one was confronting a long line, that would be actually a good example of a need for time off in as convenient a way as possible to vote. So, but to answer your question, yes, but it also would depend on discussions between the employee and the employer.
Any other questions? Representative Cahill.
Thank you, Mr. Chair. And thank you, Representative. In my town, and I'm not sure if this is unique, but in my town, the moderator, if there's anyone waiting in line, everyone waiting in line gets to vote. We don't close the door at the time, we just, everybody who's in line. But I applaud the effort that our new member, not newest, but new member, has put into this amendment. It's something that many employers do, as he said, voluntarily, but he's done a lot of work making this bill better.
Thank you, Representative Mandeville. Unfortunately, I have a problem. While you did a great job putting this together, I appreciate it, especially as first-time representative in the first couple of weeks here. So kudos to you. I just can't get over asking employers to pay with absentee ballots and other things available. We will be very careful in here about trying to put too many mandates on employers, so I can't support you, but thank you really for your efforts. So unless there's any other questions, I'd like the clerk to call the roll. The motion on the floor is on to pass. Oh, Representative Sullivan.
Thank you. I guess a couple things. First of all, we don't have a no excuse absentee ballot, so some people who maybe were surprised by a schedule change or something like that wouldn't have an opportunity to get an absentee ballot. And I also believe that this is a dramatic improvement over the original bill. And I guess I would ask my colleagues to support the amendment because it's simply a piece of good work. I also commend the representative for the effort he put into this. Thank you.
Representative Love.
Thank you, Mr. Chair. And just like the chair, I have the problem with the mandate on employers. If a small business had 25 employees and a small hourly rate of, hourly rate plus the benefits of, say, $20 an hour, it costs that small business $1,000 that day. I can't vote for that. Thanks.
Motion on the floor is ought to pass with amendment. Mr. Clerk, would you please call the roll, starting with Representative Seaworth? Yeah, I'm sorry, we're voting on the amendment.
Point of order.
All right, if I misspoke, don't everyone get all in the... Representative Sullivan, you called point of order, and then I heard something else over there.
Yeah, I believe the method that we usually follow is to vote on the amendment itself, and then a motion would be made ought to pass or something like that. But basically, the amendment is approved first or not, and then we either go forward with the bill as it originally was structured or as it was amended.
Correct, that's what I meant, but I didn't say it. You all knew what I meant. Anyway, you're right, duly noted. Representative Mandeville, you have a question of me?
No, just I wanted to apologize and thank you for all the kind words about my newness to the committee. I probably misspoke at the beginning in how I introduced this, so obviously I would like to see the amendment passed, raised as to be added instead of an OTP.
There's an amendment on the floor. If you are in favor of the amendment, say aye. Opposed, say nay. Mr. Clerk, please call the roll.
Seaworth,
No.
Avalani. Callum. Mackey, myself, no. Love. Borden.
No.
Turcott.
No.
Prout.
No.
Boyd. Huff.
No.
Sullivan.
Yes.
Susie. Barudi. Oh, I'm sorry, it's Pimentel. Yeah, sorry, I have to put that in there. Cahill.
Yes.
Di Silvestro.
Yes.
Schmidt.
Yes.
Toomey. Bouchard. Adjutant. Mandeville.
Yes.
Inventine.
No.
Vote is defeated 11 to 10.
The bill is out for further amendment. Is there any motions on the floor? Representative Avalani.
Mr. Chairman, I move ITL.
Is there a second? Second by Huff. Would you like to speak to your motion?
Thank you, Mr. Chairman. I think this bill has been discussed quite a bit. Mandates on businesses and this climate is just not in the cards. Thank you, Mr. Chairman.
Thank you. Any other comments? I hope in future years someone brings back a bill that says 1 hour unpaid. Maybe something that we can wrap our arms around because we do want people to vote. Are there any other comments? Seeing none, the motion on the floor is inexpedient to legislate. Please call the roll.
Seaworth.
Yes.
Avalani. Yes. Callum. Yes. Mackey. Yes. Love,
Yes.
Warden,
Yes.
Turcott. Prout,
Yes.
Boyd. Huff. Sullivan. Susie. Pimentel. Cahill.
Yes.
Di Silvestro.
Yes.
Schmidt.
No.
Toomey.
No.
Bouchard. Adjutant. Manable.
No.
Thirteen to, oh, I'm sorry, Immentine?
Yes.
I knew it didn't come out right. Okay, yeah, it's 14 to 7. Yes, 14-7. ITL.
Representative Sullivan.
So,
Representative Toomey, Representative Cahill, could you turn your microphones off? Is that all right now? Okay. What's your pleasure on the bill? Is there going to be a consent agenda or regular agenda?
Has to be
Hmm?
regular. I would request that it be regular because with
Okay,
7
that's
votes
fine.
opposed, I don't.
That's fine. I just said it didn't have to be. I just, good. All right, and please let me know who will be writing the blurb for the minority. Representative Mandeville?
I thought Sullivan, he was pointing to him, okay. I saw Sullivan saying go, okay. He's pointing to Manable, I got you.
Yeah, just usually what happens is a blurb will be written by the majority vote and the minority vote, in which you know, you probably haven't seen a House calendar yet, and it'll have comments of each. Okay. Yes.
That's the minority payments, OPTA.
Yeah, that's correct. Okay, the next item is House Bill 1538. And this is requiring prevailing wage on state-funded public works project. I recognize Representative Warden for a motion.
I move inexpedient to legislate.
Is there a second? Second by Avalani. You may speak to your motion.
Thank you, Mr. Chairman. I think the prevailing wage thing is just going to lead to higher prices. We're already suffering through higher prices and supply chain shortages, and it puts a further hindrance on the movement of capital and labor, and it's only would lead to higher taxes on New Hampshire residents. So it's inappropriate for us to pass this legislation. Thank you.
Thank you. Anyone else like to speak on this? One of the issues I had was when Gary Abbott spoke, and the hard time, how long it takes and how hard it is to get actually a prevailing wage established. So few jobs, the government sends out a request for information, the people have to send it back, and there's so few projects, they don't send the information back, and the wages it could be one project in Coas County, which would have on one project, let's say the jail they built, for instance, and that would, create that prevailing wage in that county, which could be not indicative of what's going on there. Representative Sullivan.
I just want to say, I'm going to be supporting this because frankly, I support higher wages for workers, and that's what this would accomplish. I recognize that there's some problems with it, but just the same, higher wages for workers is good for the state. It's good for the economy.
Representative Seaworth.
Thank you, Mr. Chairman. One of the concerns I have is even from the standpoint of a prevailing wage bill, the comments from Gary Abbott pointed out that there are a number of ways that prevailing wages are calculated. This bill goes back to a pre-1985 language that at least the testimony told us is probably not appropriate to the current work environment. So whatever the feeling on prevailing wage bills in general, I think this bill language was not properly considered. Thank you.
Seeing no additional comments, thank you. I guess you got the message. Seeing no further comments, the motion on the floor is inexpedient to legislate. Mr. Clerk, would you please call the roll?
Seaworth.
Yes.
Avaloni. Yes. Callum. Yes. Mackey, yes. Love.
Yes.
Warden.
Yes.
Turcott.
Yes.
Prout.
Yes.
Boyd. Yes. Huff.
Yes.
Sullivan.
No.
Susie. I forget his name again. Pimentel. No. Cahill.
No.
Di Silvestro.
No.
Schmidt.
No.
Toomey. No. Bouchard. No. Adjutant. No. Manaville. No. Infantine.
Yes. Well,
Yes, on ITL.
Yes.
Yes.
What are you looking at me like that? Scaring me like I just made a mistake.
His eyes went like.
It's ITL 11 to 10 vote.
The minority report will be done by to be determined. Okay. Next on my list is CACR 14. I'd like to call on Representative Turcott for a motion. We gotta let the clerk catch up here. CACR 14.
Thank you, Mr. Chairman. I move CACR 14 inexpedient to legislate.
I have a second on the motion. Second by, I didn't hear, Representative Avaloni. Give us a second here, the clerk to catch up here, and then Avaloni. Representative Turcott, you're recognized to speak on your motion.
Thank you, Mr. Chairman. The CACR was a constitutional amendment that would provide workers having a right to join a union. I'm unaware of any law, RSA, regulation, or anything in our state that currently prevents an individual from joining a union. So that's the reason for inexpedient to legislate.
Representative Bouchard.
I am in support of this amendment to the New Hampshire Constitution because I feel it will ensure forever the collective rights that are necessary to protect our individual rights. The right to form a collective union, which will facilitate and enhance the ability of their members to exercise core civil liberties such as the rights of association, speech, and petition. This amendment will protect the rights of individuals forever to come together over issues of mutual interest, to protect the right to communicate forever the workers, the co-workers about workplace concerns that come from the statutory right to join a union and bargain collectively. as well as defending the rights of their members forever, including by lobbying the government to defend the interests of the overall membership and by going to court to protect the rights of individual members. In closing, this amendment will end all the anti-union crusades in New Hampshire forever. Thank you, Mr. Chairman and committee members.
Representative Seaworth.
Thank you, Mr. Chairman. I am very concerned about the language of this bill. It's awfully vague about a right to join the union. Now, I've heard this over my many years on the committee. People have testified that people have a constitutional right to be a member of a union, and I happen to agree. It's protected by freedom of association, freedom of assembly. But what does this language mean? It doesn't say you have a right to be represented in the workplace by a union. It merely guarantees membership. Does that guarantee me membership? If I decide I want a Screen Actors Guild card, can I say, constitutional right, got to give it to me? Or does the union get some say in it? So I think even during the testimony, the sponsor at some point talked about all the great things this would do, and in other sentences he described how this wouldn't change certain things. I have a really hard time with an amendment that I just really don't understand what it's trying to accomplish. And so for that reason, I will be voting against it.
Any additional comments? Representative Callum.
Mr. Chairman, my position on this will be negative from the viewpoint of the Constitution as it was written, both federal and state, was amended to be amended at not just any whim, but on a serious and well-considered situation. And so I have a problem with anything where it says, well, we can amend it when we like, but on the other hand, I'm going to specify in my amendment that it's forever and unamendable. So I'll be voting no.
Thank you. Seeing no other hands, we have a motion on the floor of inexpedient to legislate on CACR 14. Mr. Clerk, please call the roll.
Seaworth.
Yes.
Avaloni. Callum.
Inexpedient to legislate is the motion.
Mackey, yes. Love.
Yes.
Borden.
Yes.
Turcott.
Yes.
Prout.
Yes.
Boyd. Huff.
Yes.
Sullivan. No. Susie. No. Pimentel. No. Cahill. Yes. Di Silvestro.
No.
Schmidt.
No.
Toomey. No. Bouchard. No. Adjutant. No. Maniville.
No.
Infantine.
Yes.
It is 12 to 8. ITL.
No. Yes.
12 to, I'm sorry.
Missing.
Yep. 12 to 1, 2, 3, 4, 5, 6.
Should be 12 to 9.
12 to 9. You're right. Sorry. 12 9.
No worries. I had not planned to do this today, but because of what happened at our last hearing, I'm sorry. Yeah, Bouchard. The last hearing having been ITL, it kind of makes CACR 28 moot. Because you can't have one without the other. Brian, Seaworth?
Mr. Chairman, you need a motion?
Yes, have I caused some confusion? I hear some people. We're going to do the CACR 28.
Mr. Chairman, I move ITL.
Second.
Okay. Moved by Avalani. Second by Turcott. Representative Avaloni, you're
Thank you,
recognized.
Thank you, Mr. Chairman. The sponsor of the trailer bill has asked for ITL, which would make this CACR invalid. Thank you.
Sorry, I'm flipping through my pages. Would anyone like to speak? Seeing none, Mr. Clerk, the motion on the floor is in explain to legislate on CACR 28. Please call the roll.
Seaworth,
Yes.
Avalani? Callum? Mackey, yes. Love? Warden?
Yes.
Turcott?
Yes.
Prout?
Yes.
Boyd? Huff?
Yes.
Sullivan?
Yes.
Susie? Pimentel? Cahill?
Yes.
Di Silvestro?
Yes.
Schmidt?
No.
Toomey? Bouchard? Adjutant? Vanderbilt? 20 to 1.
Any objections to consent? Seeing none, thank you. Now I'm going to move to House Bill 1403. This is the sister legislation establishing a commission relative to minimum wage, and I call on Representative Avalani.
Mr. Chairman, I move ITL.
1403 should be in your thing.
Is there a second? Warden, and please hold for, so I can get the clerk caught up here.
Find it.
1403.
1403. Who was that again?
Lino Avalani, ITL is the motion,
And seconded?
followed by Warden. Representative Avalani, you're recognized to speak to your motion.
Thank you, Mr. Chairman. The prime sponsor has asked us to ITL the bill, noting that there are several issues with it. Thank you.
Thank you. Would anyone like to speak? Anyone else like to speak on this? Seeing none, please call the roll.
Seaworth?
Yes.
Avalani? Yes. Callum? Yes. Mackey, yes. Love? Yes. Warden?
Yes.
Turcott? Yes. Prout?
Yes.
Boyd? Yes. Huff?
Yes.
Sullivan?
Yes.
Susie? Yes. Pimentel? Yes. Cahill? Yes. Di Silvestro?
Yes.
Schmidt?
Yes.
Toomey? Bouchard? Adjutant? Vanderbilt?
Yes.
Inventine?
Yes.
21-0.
Mr. Chairman, I move consent.
Without objection, consent. We're gonna, the chairman needs to take a 5-minute break. When we come back, we'll be looking at House Bill 1385, protecting the use of credit history and employment decisions. Please make sure that everyone has Cahill amendment. We'll be right back.
It's actually the Reed amendment to her own bill.
But you're right, CACRs need to have a roll call to a set of issues. Yeah, we should check that. you know, 3 is fine, but we had the chairman put the CICR 28%.
Oh, no. It's stacking my papers. Who wants me?
He said, I thought he said 85. Yeah. Representative Cahill, did you pass around copies of your amendment?
I did.
All right.
So the House rule says nothing may be on the consent calendar that is excluded. Doesn't specify OPD versus IED. It doesn't specify anything about categories.
Yes.
Well, if you have extras.
For some reason, it got printed twice, so I got extras.
Check the Constitution. I think it's in the
It has specifications for passing one, but not for IED only. That's my recommendation.
But what it says pass or does it say vote? Because that will make the difference with where it is.
Get so few of them. What about like a house? This is actually the first time we've had.
We've never had a city.
Really?
I don't think so.
Which bill are we on? I forgot what it was, 1485 or something?
Does anybody need the amendment for this bill? You need the amendment.
All right, folks, I am waiting for a phone call from Aaron Goulet, so if I have to interrupt again in the middle of something and you're talking, I'll let Brian deal with it before the executive session. So it's something that Representative Addington asked me to ask for, and I'm trying to get a resolution to it, so please just bear with me. House Bill 1385. I recognize Representative Cahill.
Thank you, Mr. Chair. I'd like to move Amendment 2022-0209H, which really basically just...
Thank you. Do we have a second? Second by Mandible. You're recognized to speak for your motion.
Thank you again, Mr. Chair. The language that's added to with this amendment covers a contractor employed. This was aimed at helping the Nextera, which has contractors providing security, which was not covered in the language from Congress. So this adds to that. Mr. Berkey had not heard back from his lawyers yet, but again, the idea here is that when you're applying for a job, you're not applying for a loan. You're applying for a job so that you can do the job, earn the money, pay whatever current debts you have, pay any old debts you have, and just go about your business. So the idea here is banning the credit history unless it's absolutely needed. That's the idea, to allow people to apply for a job, be considered for a job, and not have to just have this screening question take them out. And it also relates to people's privacy, which we value here in New Hampshire. So I ask you to support this amendment.
Any other comments? I respect the fact that you brought this bill. A bill has come in front of us pretty much every other year for the last 10 or 12 years. It is my opinion, and the opinion that has been shared by many people here in this committee, that by the time you take out all the people that are excluded, there's very few people that are included, and someone probably wouldn't request the prospective employee's permission to request a credit check. I just don't see it's worth their costs associated with it. However, someone who's responsible for closing up a jewelry store at night or dealing with credit card payments or dealing with anything to do with finances would be. So I don't know, as I was talking to Representative Seaworth at lunch, while we try to make everything perfect, legislation is not perfect, and it can't hit everything for every situation that could ever happen. And while not passing this may result in one person not, passing or getting a job, and that's bad. I'm sorry that occurs. Not allowing a business to do something that they feel is important to protect themselves, I can't agree with. So while I appreciate the attempts and the amendment, unfortunately, I can't support it. Representative Sullivan and then Representative Seaworth.
I guess I would just like to remind all of us that we're voting on the amendment, and I believe the amendment makes an improvement that Mr. Berkey specifically asked for, and however you feel about the underlying bill, I think the amendment takes care of a problem, and I think it would be good for the record to show that we attended to the issues that were brought before us. Thank you.
Representative Cahill.
Thank you, Mr. Chair. I would just like to address, I understand your concern, but a person who owes money doesn't necessarily mean a person who will steal money. So we're sort of I think there's a Fourth Amendment here. So you're presuming that someone who's behind on their bills might reach into the drawer and take something out or do something like this. And it's having bad credit is not a criminal offense. Thank you.
Thank you, Mr. Chairman. Regarding, we're first voting on the amendment, and I do have some discomfort with the language. I do understand it. In some ways, it's better. It also changes the line on 19 about the bona fide purpose and adds some restrictive language. And as you were saying, Mr. Chairman, there's a lot of exceptions to this, and the original language sort of granted those exceptions in one way, and this one reins it in a lot in a way that I'm not sure I fully understand. So I, for one, cannot support the amendment.
I have to respond. Representative Cahill, I'm not presuming anything. I don't perform background checks on my employees. That's just my choice. But it's up to the employer. So I'm not making any dispersion that someone has a bad credit and that they would be apt to steal. Any other comments? Seeing none. Yes, go ahead.
Yeah, I just want to clarify that I didn't suggest that you yourself were doing it, but the employer may perceive that this person is unreliable and could embezzle or whatever. I understand the situation. Thank you, sir.
Motion on the floor is the amendment. Amendment number 2022-0209H. No. Yes, on House Bill 1385. Mr. Clerk, would you please call the roll?
Seaworth?
No.
Avaloni? No. Pelham? No. Mackey? No. Love? No. Warden? No. Turcott?
No.
Kraut?
No.
Boyd? No. Huff?
No.
Sullivan?
Yes.
Susi? Yes. Pimentel? Yes. Cahill? Yes. P. Silvestro?
Yes.
Schmidt?
Yes.
Toomey?
Yes.
Bouchard? Yes. Adjutant? Yes. Manable?
Yes.
Infantine?
No.
11 to 10. Defeated.
The motion is defeated, and the bill is open to further motions. Representative Seaworth.
I'd like to make a motion inexpedient to legislate.
Second by Avalani. You may speak to your motion.
Thank you, Mr. Chairman. You've covered a lot of it. Like the chairman, I've seen this bill a number of times, and quite honestly, I'm sympathetic. In a lot of cases, employers are not well served by considering the credit history of their employees, but sometimes they are. And when this bill comes in, inevitably the process starts of lobbyists coming forward trying to make sure that their industry is accepted. In this public hearing, I heard one new exception that I hadn't thought of, and it wasn't a represented constituency. I have to imagine for every one we find, there's probably another one that we haven't thought of. So I echo the chairman's concerns about this bill. We can't make the right decision for every single employee in the state, and for that reason, I recommend ITL.
Mike, Representative Cahill, would you like to speak?
Just a miscommunication here. I've been assigned the blurb.
Oh, okay. Seeing there's no other comments, Mr. Clerk, please call the roll.
Seaworth?
Yes.
Avalani? Yes. Callum? Yes. Mackey? Yes. Love? Yes. Warden? Yes. Turcott?
Yes.
Prout?
Yes.
Boyd? Yes. Huff?
Yes.
Sullivan?
No.
Susie? Yes. Pimentel? Yes. Cahill? No. Di Silvestro?
Yes.
Schmidt?
Yes.
Toomey? Bouchard? Yes. Adjutant? Yes. Manival? No. Infantine?
No.
No?
Oh, yes, sorry.
Yes?
That's why I raised my eyes. I knew you were going to do it later.
ITL 17-4. 17-4.
Representative Sullivan, ready for 1386?
I need info here. Is someone doing a minority? Cahill, minority?
Next bill is House Bill 1386, Study Committee, the Effects of Heat, and is, I'm going to call Representative Sullivan for a motion.
Thank you, Mr. Chairman. I would like to move amendment number 022-0203H.
Have a second? Second by Representative Cahill.
What bill was this? I'm sorry, I got lost.
1386.
1386.
Amendment by Representative
I
Sullivan,
gotta find it first.
seconded by Representative Cahill. Just give me a second here for the clerk. You're next. Next one. If you're looking through your list, the next bill is going to be 1156. But this is 1386. Yeah, I was going to do yours and ITL that one. Yes. Yeah, okay, okay. 1304.
That was Sullivan and who?
Cahill.
Sullivan Cahill.
May I speak to my amendment?
Yes, I just want to make sure you got.
Yeah, I
caught
got
up.
it. Yeah, all set.
Yes, go
Thank
ahead,
you.
Representative Sullivan.
Okay, basically, this amendment, my name's on this amendment as a courtesy to two prime sponsors. One of them is Representative Reed, who's the prime sponsor for 1386. The other is Representative Perez, who is the prime sponsor for 1304, which was on our slate to be heard today. And I understand that Rep. Perez was had a medical emergency and was unable to make it. But regardless, both reps agreed to this, and the reason for the amendment is simply that we ended up with two bills that were incredibly similar, and it didn't make sense to have them in competition with each other. It made better sense to simply combine them because one of them dealt with heat in the workplace, referencing mostly interior spaces. The other one dealt with heat and cold, referencing primarily outdoor spaces. So this amendment combines both of them to the satisfaction of both prime sponsors. I think it just cleans things up for the committee and makes it clearer for us to move forward on the issue that was put before us. So I ask for your support simply because it makes our work tidier. Thank you.
Anyone else like to speak on the motion? Seeing none, the motion on the floor is are you in favor of the amendment? Brian, could you read to me? I'm sorry.
0203H.
Clerk can call the roll.
Seaworth,
Yes.
Avalani. Callum. Mackey, yes. Love. Warden. Turcott. Rout.
Yes.
Boyd. Huff.
Yes.
Sullivan.
Yes.
Susie. Baruti. Oh, I'm sorry, Pimentel. Cahill.
Yes.
Di Silvestro.
Yes.
Schmidt.
Yes.
Toomey. Bouchard. Edgerton. Manaville. Infantine.
Yes.
21-0.
Motion passed. Up for further motion, Representative Sullivan.
I move ought to pass with amendment.
Seconded by Representative Susi. You're recognized to speak to your motion.
I do believe that there are problems in the workplace with temperatures. OSHA recently came up with guidance on cold temperatures, I believe it was. No, it was heat in the workplace, and essentially they've got a new tool for employers to use to assist their employees. And I think the way this amended bill is put together, it provides for studying these things to figure out what types of guidance we can give to employers to help keep their workers safe. And I'm all about worker safety, and that's what this bill does. So I ask for your support for ought to pass amendment. Thank you.
Representative Seaworth.
Thank you, Mr. Chairman. I am going to vote against this motion. One issue I have, we had to postpone this vote because we had difficulty getting the people here to work on it. We have a shortage of people. We have a shortage of facilities. There are a lot of concerns about people meeting, and I think we have to be very cautious about how much we set aside to study in the upcoming months, given all those conditions. I'm told that as much trouble as we have, the Senate is even more hard on this, and they're not going to entertain a lot of studies being passed. If my namesake from across the aisle thinks back to the previous session, I gave a similar comment to a study bill that he proposed, and I ended up supporting that on the House floor, and it passed and has been enacted. I think there are some differences here, and for the future, I want to comment just on a couple of them. The bill to study the OSHA requirements for state workers had been a long time getting ready. It had been submitted as a previous bill. Before that, there was an advocacy group that had been working hard on it. And I think in putting forth that study, the sponsors knew very well what they were trying to accomplish, where they would get the information, and what that information would be doing once passed. We as legislators are not, well, most of us are not scientists or data analysts. We legislate. We get involved in that. There ought to be a law point in the process. And I fully sympathize with the sponsor. She made the comment that she's done as much work as she could. She's looking for help. I would suggest that there's maybe a little bit further to go between, it seems like there's a problem, let's look at all the stuff out there, and the point where we kind of see a problem, the information that'll feed into the law. So I suggest that, especially in this time, but probably in general too, this is a concept that probably needs to be worked a little more before it belongs in a legislative study committee. Thank you.
We agreed to support the amendment because we wanted to, at least you have that ability to move forward if you choose to on the floor. We have a couple problems, and I'd like to just reiterate what the Vice Chairman said. You know how hard it is to find a senator. They're not willing to play right now. The Speaker doesn't want a lot of study committees because certain individuals don't want to even come to the State House. So this kind of defeats the purpose of, they don't want to come to the State House, but yet we want to have study committees to come to the State House and study. I went online over the weekend and looked under OSHA and a few other things, and there are volumes on heat prevention, all these things that are there. So I'm not going to support this, but what I will do is, as chairman of the other study committee, you can add this to that, since we already have a senator, which we're probably not going to get another senator to this, and that's what a compromise I can make, that it will be, and then those discussions, we can bring that up. So I won't be supporting it, but at least your amendment was well appreciated. Anyone else like to speak? Motion on the floor is ought to pass with amendment. If you're in favor, you vote yes. If you're opposed, you vote no. Mr. Clerk.
Seaworth?
No.
Avaloni? No. Callum? No. Mackey? No. Love? No. Warden?
No.
Turcott?
No.
Prout?
No.
Boyd? No. Huff?
No.
Sullivan?
Yes.
Susie? Pimentel? Cahill? No. Di Silvestro?
Yes.
Schmidt?
No.
Toomey? Bouchard? Adjutant? Maniville?
No.
Infantine?
No. Motion fails. Open for
15 to
future.
6.
I recognize Representative Seaworth.
I move inexpedient to legislate.
You're seconded by Representative Warden. You're recognized as, I'll let me give John a little check.
Yes, I'm getting there.
I believe I've already said plenty, so I'll pass on that. Thank you.
We can just wait a few minutes here.
Who's the second?
Warden. The motion's been made, seconded. The motion maker has stated their piece. Any additional discussion? Representative Maniville.
Mr. Chairman, thank you. Could I just understand if what you said previously was that your concept was that the subject matter that's contained within this bill could be subject matter for an existing study committee?
Then I would be willing to add it to that in that discussion.
Thank you.
That's correct. That study committee has a mission to deal with utilizing, making municipalities adhere to OSHA. I think it's germane enough that if the committee's willing to do it, we'll see. That's Brian. Who's in the committee with me? Lino, myself, Brian, and a senator. If they are all in agreement, we can. If not, but at least it provides that possible mechanism to that happen. All right, seeing no others, call the roll.
Seaworth,
Yes.
Avalani? Callum? Mackey, yes. Love? Warden? Turcott? Prout?
Yes.
Boyd? Huff?
Yes.
Sullivan?
Yes.
Susie? Pimentel? Cahill?
Yes.
Di Silvestro?
Yes.
Schmidt?
Yes.
Toomey? Bouchard? Adjutant? Manival? 21-0.
Yes.
Oh, Evan. Every time. Now it's 21-0.
Consent, all right. House Bill 1304 establishes a committee to set the impact of outdoor working conditions in heat and cold. This was the kind of the similar bill. Make a motion, Representative Seaworth.
I move in expedient to legislate.
Second by Representative Sullivan.
That was Seaworth Sullivan?
Yes. Representative Seaworth, you're recognized to speak on your motion.
Thank you. And my motion was simply, we combine the two bills into one, and so this one is no longer necessary.
Anyone else be wishing to speak? Seeing none, the motion on the floor is inexpedient to legislate, and we'll call the roll in a few minutes.
Yep, I'm all set.
All right.
If you are.
Go ahead.
Seaworth?
Yes.
Avalani? Yes. Callum? Yes. Mackey, yes. Love? Yes. Warden?
Yes.
Turcott? Yes. Prout?
Yes.
Boyd? Yes. Huff?
Yes.
Sullivan?
Yes.
Susie? Yes. Pimentel? Yes. Cahill? Yes. Di Silvestro?
Yes.
Schmidt?
Yes.
Toomey? Yes. Bouchard? Yes. Adjutant? Yes. Manival?
Yes.
Infantine?
Yes.
21-0.
All right. On consent.
Consent.
House Bill 1156, requiring certain public servants to receive a copy of pre-employment background investigation. I recognize Representative Turcott for a motion. 1156. What was that, Lino?
Correct. I move 1156, inexpedient to legislate.
Motion on the floor, inexpedient legislate, seconded by Representative Avalani. Moment, please. 1156. It's okay. Only have half of them. It's not here. Let me have another half. 1156 is what we're looking for, John. Tom, why don't you just write on one of these, and then you can ask for another one from Heather. It looks like it is missing.
My bad, right here.
Okay, the motion was made by Representative Turcott on House Bill 1156. It was seconded by Representative Avalani. Your motion was ITL. Representative Turcott, you're recognized for your motion. Speak of your motion.
Thank you, Mr. Chairman. We heard extensive testimony by two individuals in law enforcement who conduct these background investigations. Both of them were adamant that they thought this was not a good idea. The other issue, or the other point that they made is out of the hundreds that they've done, only one or two have actually ever, one was requested, one ended up, I think, in court, and they've only been required to turn over something one time, if I recall. They also mentioned the potential for additional litigation, and it's just, overall, it's not a good idea. They sign off, if they're applying for employment, they're obviously signing off on something that allows the background check and investigation. And final point, as a couple of them said, generally, when they're denied employment, they know the reason why. So for those reasons, I support ITL.
Thank you. Would anyone else like to speak? Representative Sullivan.
I have to say that when I first saw this, it didn't strike me as being a law enforcement issue. So I was frankly in favor of providing these background checks. Good example of when a hearing makes a difference. There are two very impressive individuals who testified, and I was clearly persuaded that turning over these background checks would violate some confidentiality that would be detrimental to the process and possibly detrimental to people who provide information. On the way home, I was thinking to myself that probably not everyone who does background checks are as exceptional as those two folks were. But that being said, I was certainly persuaded that turning over these background checks would be a bad idea. So I will vote in favor of the ITL.
This was a difficult one for me because I like transparency in government, and to not let someone see that at first blush was disconcerting. I know this is not just for police, it's fire and other. Police in our society right now are under considerable scrutiny, and one of the comments was made by the chief, so I'll just repeat it. We don't want a bad apple, so they have to look at all these background checks. And so to me, it's like, okay, so what's the check and balance to make sure it's just not a personal issue? Well, it's only happened a few times. If you want, you can file a suit, and that's all discoverable. You get that discovery. If the police think that through that discovery process that they probably don't want to give up that information about something, especially if it was maybe a neighbor or an ex-relationship or something. So then it can go in front of a judge, and it's called in camera, where the judge will sit there in front of the courtroom with both attorneys, and he'll look at it. And he'll make a determination of whether or not that really should be given up or not, without having to put anyone possibly in any jeopardy. So there are mechanisms, and that with that, I believe that while we do need to have transparency in government, this might be a place where the transparency happens, but a further couple down the line. So I'll be supporting the motion of ITL. Any further comments? Seeing none, the motion on the floor is inexpedient to legislate. Mr. Clerk, would you please call the roll?
Seaworth?
Yes.
Avalani? Yes. Callum? Yes. Mackey? No. Love? Yes. Warden,
No.
Turcott? Prout,
Yes.
Boyd? Huff? Sullivan?
Yes.
Susie? Pimentel? Cahill?
Yes.
Di Silvestro?
Yes.
Schmidt?
Yes.
Toomey? Bouchard? Adjutant? Manaville?
Yes.
Infantine?
Yes.
19 to 2.
I'm okay with the consent, but I'll defer to Representative Mackey.
I'm okay with consent too.
All right, thank you. One last one, folks. House Bill 1231, relative to failure to make payment or compensation. I recognize Representative Avalani.
Thank you, Mr. Chairman. I move ITL.
Is there a second? Second, Warden. Sure. Yeah, he was excited. 1231. I think there's a few other people here that need to make some seconds.
Who made that again? I missed it, sorry.
Avalani, seconded by a very excited Warden.
And that was ITL.
Yes. Representative Avalani, you're recognized to speak to your motion.
Thank you, Mr. Chairman. There was some back and forth with the department about whether carriers should make payments directly, whether the department should make payments directly, how many issues there actually are per year. I suggest if there's really an issue, we should take it up with the department and come back with something better than this legislation. Thank you, Mr. Chairman.
Thank you. I agree. We, Representative Turcott, Seaworth and I had some considerable discussions about it. You know, should it be part of the fine? Should it be a third of the fine? What should it be? I know there were some other calls made to the department trying to figure out how many. I thoroughly agree that if someone is in a position where they're just egregious and they're continuously late paying people, that there's a potential where a fine should be made, as well as then maybe compensation to the employee or to the injured worker for having to wait. We need some data as to how often it happens, how frequent it happens. Are they mostly a day? They didn't have a lot of the information we needed, and they rarely utilize this. So we don't know whether or not this is a problem, and whether, and I'm all in favor of making it much harsher if it seems to be continuous with certain insurance carriers. I am aware 3 or 4 years ago there was one, and someone was brought to the carpet and almost lost their license to transact business in the state until they straightened up. So the department does seem to get on these things. We get some better information from the department, and we find that it is a problem. I know the Vice Chairman and I have discussed about bringing future legislation. Representative Sullivan.
This bill didn't really address the issue that I think most of us recognize as the more serious issue, which is late payments of regular weekly compensation. Instead, it was looking at the length of time it took to get a hearing done and then get the compensation approved. It seemed that hearings get delayed by no fault of anybody's, and the penalties could come into play without it really being the fault of anyone. So I guess I would like to see a bill that addresses late payments of regular compensation checks rather than a slower than desirable hearing process. I'm going to vote in favor of the ITL.
Any other comments? Seeing none, the motion on the floor is inexpedient to legislate. Mr. Clerk, would you please call the roll?
Seaworth,
Yes.
Avaloni. Yes. Callum. Yes. Mackey, yes. Love. Yes. Warden.
Yes.
Turcott.
Yes.
Trout.
Yes.
Boyd. Yes. Huff. Yes. Sullivan.
Yes.
Susie. Yes. Pimentel. Yes. Cahill. Yes. Di Silvestro.
Yes.
Schmidt.
Yes.
Toomey. Toomey? Oh, he left, okay. Bouchard? Adjutant? Maniville? 20-0.
Consent agenda. All right.
Mr. Chairman. Okay. It doesn't matter, I just thought you had said we were
Yeah.
gonna do this one, but.
We could do more, but Representative Toomey's left. I want to be fair to everybody, and there could be some, whatever. So we've done more than I expected to do, so I'm ready to close the executive session, if that's all right.
Question for the chair.
Yes.
On those bills we exec today, when do you need the majority and minority reports?
By 5:15. I only need the ones on 12:07 and 15:38 by Monday of next week. Would be best. They're due on Thursday, but I like to have them by Monday so we don't crush Heather. And the other ones, sometime next week, get to me, so we can have them for the following week if we have a session, a House session. Avalani?
Thank you, Mr. Chairman. Do we have another bill scheduled for today?
We could, I just, because someone left, unless it's something you really want, I would wait till the next, it's not on the.
1076? Wasn't that today as well?
Again, it could be, but, oh no, I'm sorry, 1076, yes, we were going to do that, just so, let me just close, okay. Slow down here. Representative Adjun and I have worked on an amendment to House Bill 1076, okay? Most of you didn't get it for the last couple hours. You folks asked me in caucus not to present it today because you needed to review it. That's, yes. We are definitely doing it. We are definitely doing it next Thursday. It'll be the first order of business next Thursday in our executive session. I might even do it quickly between a bill we have. So please, if you have questions on it, I would appreciate if you'd look at it. Email either Representative Adjun or I. Okay. That being said, I've kept you long enough. Thank you very much. We're close the Labor Committee hearing session for the day, and I'll be here if you have anything else.
Mr. Clerk, that last one.